Heyo, folks! Yeah, I thought we would start with a little song. And yeah, I have had a lot of fun with Stuno. Now they seem to be in a bit of trouble with a few of the major labels claiming copyright infringement. Uh, I might do a thing on that later on when I get the time for it. Welcome to the catch-up stream. Hi, Sylvia, Gigi, and Silver Girl. I saw Dave, and there's a few of you here. I know AV is live now, so I don't mind. She's doing great content. Now, today it is Dirk. Thanks, Nick. Now my neck hurts. I'm getting too old to headbang. Oh, you're never too old to headbang. Now, this is a catch-up, recap, let's get up-to-date stream. But also, it is ask the questions, because this trial has been going on since November 28th of last year, and I have been here from the very start. I've been here. I saw the opening statements. I saw all the crap show, all of it, up until now. Now, if I can answer your questions, that's another issue. Some of it starts to blend together because it's all crap. I'll adjust this a bit. I don't know why it's doing that. Now, with me, I have my cooler. And what's in that cooler? Well, it's a few beers, just in case. Yeah, it's actually in the case. Oh. Yeah, I know. For you, it is barely after lunch. For me, it's 7 p.m. And I think I just serve a beer after my work week. So. Nordic Lights is the name of this beer. Oh. All right, but what we will start with is the final day Woody was on the stand, and I admit I was so tired of all the things that I didn't even bother to watch it. And I think I robbed you guys of an experience, because afterwards, when I got back to see a bit of it, it is quite enjoyable in its own weird kind of thing. Thank you, Silver Girl. Yeah, this is a gift from Drunk Me. You see, once in a while, I have a grift stream of sorts where people pay for me to spin the wheel of regrets. And it involves a few shots. And when I am quite intoxicated, I like to go on these cheap buy stuff websites. And since it takes 6 to 8 weeks for it to arrive, I kind of forget about it. And this is one of the things that I bought to myself after one of those. Yeah. So thank you. Yeah, I quite enjoyed these things. I have a bright yellow one as well. I have a poker one and a few. I got a hot dog onesie. So yeah, weird stuff do arrive in the mailbox once in a while. Now, what I started to say was, I think I robbed you guys of the Woody experience. And it's my fault, I admit. I was so sick of it, and all the judge shenanigans and the bad rulings and the prosecution's misconduct. I just couldn't. But now I've been I got some rest. Now, heavy work week for me at work, but it got my mind off things, and now I feel I'm refreshed. So, let's see here. This last day of Woody testimony.
For the morning, Mr. Stillwell
Let me know if you
and
have
Mr. Sharp. Good morning. All right, Mr. Williams, Mr. Steele, Mr. Adams, Mr. Pines. Good morning. Ms. Haltwinger. Good morning. All right, Mr. Kendrick and Mr. Weinstein. Good morning. Mr. Ewing, Mr. Matthews. Okay. Sergeant Brown, all our jurors here?
Present.
Okay, all right. Councils, anything else we need to take up before we call our jurors?
Yes, Your Honor.
Hit the thumbs up. You know,
The senior T is coming down.
you know it works.
May I be excused when she arrives?
Yes, Mr. Typhoid, you certainly may be. I hope you feel better, okay? All right, Mr. Weinstein, yes. Whenever she comes in, we'll tag her in, okay? All right, thank you, sir. All right, okay, anything else?
Yes, Your Honor.
All right.
Your Honor, given Mr. Copeland's testimony last week, the state does intend to play his interviews beginning today until whenever those interviews finish, at least for the January 11th, January 28th, February 20th, and February 21st.
Yeah, and there was a debate. And of course, even though the prosecution for a week and a half at this point have gone through those police interviews in their questioning off, now they want to play all of it.
Interviews. Last night, the state sent over redactions as it relates to the June 10th interview, which I believe defense counsel may have some portions that they also want to have redacted. And so the state would ask that we can move forward today with the first 4 interviews. We'll see where the day leads. And then tomorrow have some litigation if necessary regarding the June 10th interviews.
Are you talking about the interviews which occurred where?
Back in 2015 at Atlanta Police Department, which the state believes could enter based on Mr. Copeland's testimony that everything he said in those interviews were lies, that he said anything that he wanted to say in order to get out of that interview, that we are impeaching him by contradiction and playing those statements. We will begin with the January 11th statements, and then we're going to move to the February 20th statement. And the reason why
January 11th and then February 20th and those of 2015?
Those are both in 2015. And the reason why we're going to start with those two, Your Honor, we believe those two have the least amount of information that the defense may argue. So I think that those are easier to get through. The January 28th and the February 21st interviews, both of 2015, may have some more redactions that defense counsel may want. And so we're open to hearing what, if anything, they want redacted. So we can either consent to some things or have some litigation about that. But we're going to start with what I believe to be the easier interviews, which will be January 11th and February 20th. And then we'll move to January 28th, February 21st, and then June 10th of 2015.
Okay. All right, let me hear from any defense counsel about the state's plan to play the January 11th and February 20th interviews.
So, good morning, Your Honor.
Good morning, sir.
So there's a couple things. Regarding just playing past interviews, it's going to be my stance on behalf of Mr. Stillwell and probably others that the foundation for prior inconsistent statements has not been laid in toto for the entire interviews to be played. Now, there may be specific snippets, but just to play the interview, We do not believe that the proper foundation has been laid. That being said, if the interviews are played, I understand what the state is saying, and Ms. Hilton communicated with me this morning, and I appreciate that. The first two interviews,
First two interviews, and tell me what date those are.
January 11th,
And February 20th?
February 20th.
Okay.
So those are interviews, and quite honestly, I've been focusing on the June 10th. I would ask that the defense have a little time just to look at those transcripts to just make sure if Your Honor is going to allow those interviews to be played over our objection or over our hearsay objection, to just make certain that there's nothing in those interviews that should not be played, that would fail 403 balancing, character evidence, etc. As we look forward, just for planning purposes, I have not, we were just sent the proposed redactions in a form that we could open them from the state. The June 10th interview, if it's allowed, is very problematic as far as Mr. Copeland talking about things he doesn't have personal knowledge of, talking about hearsay, bad character. It's just a very.
I think they want to litigate that separately.
Well,
So tell me about they're saying it's going to take a minute to get through the June 11th and February 20th interviews.
And I understand that. All I'm saying is I'm just trying to give Your Honor a heads up that the June 10th, there may be a substantial amount of time that we may be asking for your attention outside the presence of the jury. I'm just trying to give the court a heads up on that.
Okay, but
Yeah.
so when I think the state said that too. So
Okay,
there's
so
a disagreement about
So the first two interviews, I would just ask that the defense team be allowed. I don't know if the state is planning on going into it right now. If they are, I would ask that we be given some time to just review it, because
Hi, Dirk asks, is Lil Woody in custody right now? No. Woody is out on the streets. He have an Instagram, and he's posting quite interesting stuff. It's been shared on Twitter as well. So, yeah, he is out and about, and I know I joke around with, I have very, very few Fs left to give in my life, because I believe we are born with a certain amount. I used to give a lot of Fs when I was younger, now not so more. I don't think Mr. Copeland was born with any F to give. He is not afraid of anyone or anybody. So when the prosecution indicates that, oh, he might be scared, no, Woody doesn't get scared, ever. So yeah, no, but little Woody is out and about.
we were not anticipating this morning, and just comparing our notes to see if we have any objections.
Well, I think that, well, let me just correct you, Mr. Shark, just a second. Friday, the state did tell you that they planned on playing those two, at least they planned on playing those particular interviews in.
And here he goes again, Judge, not listening. Now it's with proposed redactions. The defense doesn't know what redactions, because they await the prosecution's redactions, so they don't argue the same redactions. That's proper conduct. Wait for the prosecution to offer redactions and then suggest more. Until they know, they cannot prepare. But this, Judge Glanville, doesn't care about protocol.
Total for impeachment. They said that up at the bench on Friday. So, so you had all weekend to kind of go through that. If that were the case, it's not like they're playing hide the ball. It's not like, given the current testimony so far, that wouldn't be probably a realistic possibility.
Well, I mean, we do have our objections, or I have my objections to that. But again, Your Honor, I would just ask that the defense attorney be allowed to huddle up and figure out, because I'm up here, but I'm not necessarily speaking for everyone, and I'd like the opportunity to communicate with counsel for the other defendants.
How long you had the January 11th interviews? You had them. When were they?
Probably. I mean,
it doesn't matter, kind of. It does not matter how long they have had it. It just doesn't.
It's not, Judge, just to be clear, it's not a matter that I haven't watched them. I probably watched them 24 times,
Okay.
but it's just a matter of having the transcript pages where there's problematic issues.
Okay. Unless you,
And again, Your Honor, I haven't looked at what the state's redactions are. They sent something at 11 o'clock last night with proposed redactions. It wouldn't open, so they resent it this morning, probably, 20 minutes ago. So I haven't had a chance to look at their proposed redactions.
And to be clear, the redactions are for the June 10th interview.
See.
The state believes that, again, for the January 11th and February 20th, we don't have any redactions for those two. But again,
You're
we're
saying-
open to hear
all right,
whatever.
let me ask you another question. Mr. Sharks indicated that he doesn't believe that the foundation has been laid for a prior inconsistent statement. You want to address that?
Yes, Your Honor, we're not asking to bring this in for prior inconsistent statements. We're asking to bring it in under 24-6-607 and 24-6-621, which is impeachment by contradiction, in which
Here's my opinion. Impeachment by contradiction, for that to be valid, there has to be a contradiction, a spoken contradiction that they can impeach on. What they want is to impeach Woody saying under oath that he was lying back then. By playing these videos, they want to show the jury, don't believe him when he says he is, don't believe him now under oath. And believe what he said back then, 10 years ago. Here's my issue with that. If you make that claim, you also have to admit you knowingly put a person on the stand to perjure themselves. Now, I know that the statute doesn't say lying. I lied back then. Might not be a perjury. Might not be perjury. I know that. But that is the contradiction in the state's case, what they argue. Because they want to have the cake and eat it too. They want to both claim he's lying on the stand. They won't prosecute him for perjury because allegedly they offered him immunity for lying on the stand, except if he admitted to be the culprit in the Donovan Thomas ending. So, yeah, if anything needs a purge, it's this trial because it is infuriatingly bad. And it's a waste of money and time for everybody involved.
a witness may be impeached by contradiction in several ways, either close questioning, and I'm reading, Your Honor, from Carlson's on evidence, page 265, 8th edition, page 265. A witness may be impeached by contradiction in several ways, close questioning to elicit concessions of error, 2, questioning a witness about the substance of implication of evidence
Exactly
already
what
produced during the case, confronting
This is
the
all-
witness with his or her own
Everything they argue here should have been done pre-trial. And remember, the prosecution said they were ready for trial in December of 2022. Then the trial started in late November 2023. They had almost a full year doing all this pre-trial. And the prosecution chose not to. They're choosing to litigate in the middle of the trial.
contradictory prior statements. And that's what I want to focus on, Your Honor. Mr. Copeland testified repeatedly during trial last week that everything he said in those interviews was a lie, that he was just saying whatever he wanted to say in order to get out of there, that the officers were pressuring him to speak about Thug, that in the first interview, he did not come down there on his own. He only came at the request of law enforcement. And we believe each of these interviews contradict everything that he testified to in before this jury, Your Honor. So we believe that at this point, it is right to show impeachment by contradiction.
Well, and if there's certain things that are said that indicate that the officers did not pressure him about quote unquote thug or things like that, that maybe fall under contradiction, but playing the whole video, it's like they're saying he said he lied, and we're bringing this to as contradiction, evidence of contradiction. But that would be assuming that he's telling the truth in that interview. It doesn't in and of itself facially contradict anything he's saying. He's just saying he lied.
Ordinarily, you'd be right. It would be impeached as to specific things. The challenge in this particular circumstance is that Mr. Copeland's repeatedly said, I lied about everything. And I lied I told a lie as to what would get me out of this. So I think under those circumstances, this is kind of the broadening of it. Because of his testimony, the entirety of that particular interview is probably going to be admissibly delayed. Respectfully, over your objection.
I understand, but this is a problem that was created by the state, and they're trying to.
Just slow down.
Oh, again, judge is not allowing the defense to finish their argument, which is incredibly rude. Now, in Supreme Court or appeals court, you expect to be abruptly stopped in your tracks. In trial, you are supposed to be able to finish your argument, and the judge denies it. And the more I think about it, the more I believe it is for the judge to get as little as possible of the defense argument into record. Because if they can't finish their argument on appeals level, it might be invalid because they didn't finish the argument towards Judge Glanville.
How did the state make this a problem when the witness testified, not just once, but repeatedly over the last several days, that he has lied about these particular interviews? He was lying because he wanted to get out of this. He told these people anything that he thought that would work. And so that's kind of the predicate. Ordinarily, sir, I would agree. I would totally agree with you, but I don't think the state set this particular witness up for that particular saying. He said it more than once.
Okay, I'd like to answer your question about how the state set this up. The state, we know that the state met with Kenneth Copeland. What was it, 2 weeks ago now? We know we were arguing about whether his attorney was alerted, etc. They met with him, I guess, in the courthouse. I don't know. We know that they met with him. Unlike every other witness, they've done this with several of the people that are alleged to be associates of our clients. They have been asking about statements from 10 years ago, and they intentionally have not afforded these witnesses an opportunity to review their past statements prior to testifying. So they want to play their past statements. They want, I don't recall. And so they bring these gentlemen in, ask them about statements that were made 10 years ago, and have never given them an opportunity. We know that the state, they're thorough. We know typically in trial, when the state is calling a witness, they say, hey, we want you to come into our office. We want you to sit down and review what you said in the past. And they do that regularly in trial prep. They have chosen not to do that for Kenneth Copeland. They chose not to do that for Trontavious Stevens. They have chosen to keep these gentlemen in the dark and then ask them questions about statements they allegedly made 10 years ago. And when the gentlemen say, I don't recall, which is pretty understandable, then say, we get to get into prior inconsistent statements. We get to get into impeachment by contradiction. That was their choice. They should have let these gentlemen review their statements before taking the stand, and we probably would be in a different place. So that's why I'm saying this is a bit a situation that they created. It was strategic by the state, and they shouldn't benefit from it.
Okay.
Your Honor, respond to that.
Madam?
No.
No, yeah, go ahead.
Your Honor,
And now,
Mr. Sharp keeps addressing again prior inconsistent statements. What we expect for any of our witnesses to do is come in here and tell the truth about what they remember happening in 2015, given why they're here. What Mr. Copeland said is everything I said was a lie. So at this point, Your Honor, it's not about, he's literally saying everything I said is a lie. I told them lies back in 2015 just to get out of trouble. And what we are saying now is we don't believe that to be true. The jury can make an assessment based on his trial testimony and what he said previously and determine by his body language, by how he testified, by how he spoke to law enforcement, about what was asked of him, how he responded, whether or not they believe that everything he said previously is contradicted by how he acted in court. And so again, Your Honor, Mr. Shar is focusing on prior inconsistent statements. Again, we're impeaching by contradiction, meaning what he said in court is distinguishable from what he said previously in 2015, one, outside of the presence of these individuals, and how he testified, which was that line of questioning that we asked of Mr. Copeland.
Okay.
Here is the insinuation from the state that he's telling now that he's lying because he's scared of the defendants. And we've been through this. Mr. Copeland is not afraid of anyone. That is a ridiculous claim.
Anybody else wish to be heard on this issue? Mr. Steele? You can come to the podium, sir, if you'd like. Maybe it'll be easier for you, but.
So my notes do not reflect that Mr. Copeland gave a blanket, everything I said previously is a lie. What I have is he would answer some questions, probably did. Other questions, yes, I remember that. And some questions, that was a lie. So we need to go, we have a duty not to just play prior statements that are not inconsistent and do not impeach current testimony. In addition,
They're not saying it's impeachment. They're saying testimony by prior contradiction.
it's an impeachment way to do it, but it's not impeachment for some things. Other things, sure. He said, I said anything to get out of trouble, to get the police to stop investigating me, or words to that effect, and put them on someone else. Also, there are detectives. There is Detective Thorpe in the January 11th, early morning hours, 2015, video audio recording, and there are other officers. Those officers give statements as well. Now, some of the statements have to put in context, so the rule of completeness. However, other statements, the detectives are giving information that do not put anything in context. It's their opinion. So I do believe, I agree with everything and endorse everything Mr. Short said, but I do believe that the state needs to be more focused and not just say they're playing everything. And then obviously bring it to the court with any other issues that we have. If the state's position is what it is, and my position is that the court needs to make findings on each line because they're not all inconsistent under 24-6-602 or anything on 24-6-613.
All right, Chris. Oh, we're gonna see if we can search for that. Anybody else wish to be heard on this issue? Okay. Chris, how long will it take you? 5 minutes? Okay, we're gonna recess for 5 minutes and I'll see if we can find that particular statement and see where we go from there, okay? All right, we're gonna recess 5 minutes. President Trump, I would have told a story about Trump. If they would have asked me about you, I would have had a story about you. Whatever to convince them
And
that I
here
ain't
is
doing
when the
nothing.
judge
It wasn't me.
almost comes
That's
to
what my
the
intention was.
conclusion.
So when you're asking me about interviews, I keep telling you, you keep asking me step by when they get it allows
So let's see.
provided testimony that from somebody that openly haven't found think what you want to do.
We believe that he's being contradicted about what he's saying in court versus what he said in 2015.
Okay. Ms. Sharp?
I think you have it exactly right, Judge. These rules are not so broad as to just allow hours-long statements in based on specific denials. The idea that I think you also should consider is within your purview to consider the gamesmanship.
I'm going to stop you there. I don't think that anybody's playing and running games in terms of
Well, I think that they,
I respectfully disagree with you about that. Okay?
so you don't think that they specifically chose not to show this gentleman his video so he would not recall things when asked about
I don't
10-year-old
think
statements?
I don't think that any self-righteous advocate worth their salt is not going to prepare a witness. I don't believe.
Judge Glanville is absolutely correct here.
Asked about
I don't
10-year-old
think
statements?
I don't think that any self-righteous advocate worth their salt is not going to prepare a witness.
I don't believe an attorney worth the salary would not prepare the witness. And I agree, completely agree, because the prosecution are attorneys who does not deserve their salaries. They cheat, they lie, they misrepresent, they do misconduct, anything to get a win. And you're helping them, Judge Glanville. You don't deserve your position, Judge Glanville.
If you would do that, I don't believe anybody would do
Well,
that.
why hasn't he seen the videos then?
I don't know, sir. I don't.
Okay.
I don't. And I don't know what their prep entails. But again, we're not going into, ad hominem attacks against anybody. Okay.
It's not an attack. I just think it was strategy, and they shouldn't benefit from the strategy. I'm not making a personal attack. I mean,
No, but there are pros and cons about how witnesses are prepped. So, I certainly,
right.
I certainly think that is something that, has to be taken into account depending upon the witness and depending upon the circumstances. So,
But they're trying to say just because he doesn't remember, recall, or denies specific parts, somehow this opens up the entire statement based on, well, the jurors should get to see his demeanor. And again, they can see his demeanor on the specific part that is being impeached. Impeachment by
But I'm concerned about this last couple statements about, because he says, when you're asking me about interviews, that's broad. He's saying in these interviews that I have been undergoing, I keep telling you, you keep asking me step by step, 7-9. This is what I did. So when they got me this day, I was going to jail. I tried to come up with something to tell him. That's why I can't tell you what I said. I was making it up.
In my observations, he's frustrated because he doesn't understand the rules of evidence. He doesn't understand that the state was trying to lay a foundation for prior inconsistent statements. But just because he's frustrated and doesn't answer the question, and it, quite honestly, is non-responsive, that doesn't mean the foundation was laid. They still have to lay the foundation.
The impeachment and or the prior inconsistent statement is a collateral consequence of what the witness testifies to. If the witness gives pretty straightforward testimony, then there's no need to go into any of the other things about prior inconsistent statements or impeachment by contradiction. It doesn't come into play because there won't be anything for them to kind of bring out. So it depends on the testimony of the witness as to whether or not we even broach the subjects of impeachment or by any means or method.
And what I think maybe the advocates aren't doing the best job conveying to your honor. The first two statements are pretty straightforward. Okay. But as we move on, these statements are very. Are you
talking about the statements on January the 11th and February 20th?
They're pretty straightforward and pretty fairly compartmentalized about what they talk about. I'm going to use June 10th as an example because this is going to come up again.
Okay, but I don't want to talk about June 10th.
Well, I don't want to set a precedent
we haven't kind of covered that. I have a jury that's sitting out here. I want to kind of see if I can go forward with that. Well, so that's my intent at this point in time, is to see whether or not I can make an agreement, not make an agreement, but I can make a decision as to whether I'm going to allow the state to play these two interviews. Okay,
well, I'm just trying to make it clear to your honor.
We can go into argument about that because even the state has told me that we probably will need to have some discussion about that.
I don't, your honor's going to rule. I agreed with your honor's analysis initially. Your honor's going to rule how your honor rules. I just want to be clear that all of these statements are not the same, and any decisions made about the first statements should not be.
I'm just talking about the first two right now. Okay, so
I'm going to stand by my objection on hearsay grounds.
Sure.
And I think I speak for all my co-counsel or co-defendant counsel regarding that. And your honor will just, it's a call that you're going to make and we're going to have to deal with it. But that's our stance.
Mr. Steele, anything else, sir?
I doubt it.
Okay. All right.
And we agree to.
It's a discussion about my hair in the chat. I do use product. It's shampoo, it's conditioner, and it's a lot of conditioner. And then I have one of these, what you call it? It's one of these cap hat thingy that keeps my hair moisturized. What's it called? I don't remember. I have it somewhere. Bonnet. Thank you. Bonnet. I have one of those.
Anyone else? Mr. Harvey? Yeah.
I, at this point, renew my motion for severance and for a 105 instruction. None of this relates to Mr. Nichols.
Okay.
So I know you gave me a continuing objection. I want to renew it every now and then. We'll
Sure.
get into a position where there is a great deal of evidence that's coming in, none of which impacts Mr. Nichols.
All right, sir. So noted. Your motion for severance and your request for a 105 instruction. I'm still going to deny it. I'll give you a continue.
Yeah, Mr. Nichols is mentioned once in this entire RICO. Once. In one charge. And he has to sit through all of this crap with the risk of being convicted by association. And it's unfair. He shouldn't be there. He should be among the other severed cases. There was a hearing today. I was trying to watch it, but the sound was so horribly bad. And but it concluded in they didn't want to plead. Probably because they've seen this trial and the absolute horse shit the prosecution's case is.
Objection. All right. State, were you going to say something else, madam?
We agree as to the February 28th, January 28th, February 21st, and June 10th. We will probably need to have some litigation. That's why the state just solely want to focus on first, January 11th, and February 20th.
All right. Does the state have any case law you'd like me to rely upon? Either the defendants, defense counsel as well. Is there any case law you'd like me to look at?
However, the state will pull case law directly on point with this assertion, Your Honor.
Here's the challenge that I'm kind of coming into. It's 607 allows for the admission of to impeach specific errors or falsehoods in a witness's testimony. So it's not really broad. It's kind of
Right, and so we're looking,
it's focused. Okay, so
and we're looking at it in conjunction with 24-6-621, which is impeachment by contradiction, Your Honor.
all right.
Yeah, Ron Barnes. The state is pulling at straws, and the judge allows it.
24-6-621 states that the witness.
It's so ridiculous because they found one sentence, one line in one case and another line in another case, and then they pull it together as if that is okay to do. It isn't. But judge for months have been doing this. Months.
May be impeached by disproving the facts testified to by the witness. So when he says in court, I was just making it up, we believe that we can now show this interview, these two interviews specifically, that he's not just making it up, anything that he says. We talked specifically in the February 20th interview about snitching. And he says, you know, Tay's not the one who shot me. Matter of fact, he emphatically says, I know right now, I think he may have sworn his daughter's life that Tay did not shoot him. However, in the February 20th interview, he tells his girlfriend in a private conversation, not private, but in a conversation between the two of them, I know who shot at me. It was Tay. And so we questioned him about that instance as well, in conjunction with what happened with him, his daughter, and his child's mother. So again, both the January 11th interview as well as the February 20th interview is a complete contradiction to what he has said on the stand last week, Your Honor.
Excuse me. All right. Based upon OCGA 24-6-607 and 24-6-621, in the court's review of the witnesses, Mr. Copeland's testimony thus far, I'm going to allow the state over objection to play the interviews on January the 11th of 2015 and February the 20th of 2015. I will give all defendants a continued objection as relates to those two interviews. Those are the only two we'll take up at this point in time. And then, as we mentioned, we'll take up the other ones a little bit later, okay?
Yeah, I do have a case for record.
Before they testify. All right.
The case is going to be United States versus Courtroom, Carthen, 906.
Is it an 11th Circuit case?
Yes, Your Honor.
Can you spell that again?
Yes, United States versus Carthen, Carthen,
CRTH?
Carthen.
It says it decided January of 2013?
2018.
2018. All right. You need to give me a citation. Go ahead.
Sure, 906.
Hold on. Go ahead.
Federal Third, 1315. God bless you. And has impeachment by contradiction occurs when a party offers evidence to prove that a fact to which a witness testified is not true.
About 1315, is that what you're saying?
Yes, and let me see.
Yeah, now, as you see, Judge Glanville is allowing the prosecution to search. Now, they already made their argument. It should be done by now, and the ruling be made. But he keeps allowing them over and over again, grasping at straws, finding irrelevant case law that might have a passing that might have some relevance. It's so infuriating to watch this go on in real time to see this misconduct, this violation of due process right in front of our faces.
Oh, you're right, I think that's in the concurrence.
By Judge Pryor. Okay, 608 won't get you there. You're saying it's 621?
Yeah. Oh, by the way, last time when I had a last stream I had, I got a PayPal donation of $10 from Darlene. I didn't see that until after I finished the stream. So thank you so much, Darlene, for sponsoring this channel and allowing me to do this, because I do have costs with doing this. And I'm not even counting my time. It's just the internet, the StreamYard, the art list, all the things. So thank you so much for allowing me to at least break even on this. Thank you.
Yeah, because a majority of circuits, I believe under.
We're on like 621.
All right. Okay. The court's still of the opinion that those two statements on January 11th and February 20th of 2015 can be played for impeachment by contradiction. All right. Bless you, Mr. Weinstein. When's your replacement coming?
Yeah.
That's soon enough. Okay. All right. Hang in there. All right. Okay. All right. Sergeant Brown, summon our jurors, please.
Yeah, sadly, Mr. Weinstein got sick during this week, and apparently COVID.
Have you already gone to get Ms. Copeland?
But now it's Copeland show. Slowing it down a bit to 1.25 speed.
I'm tired.
All right, ladies and gentlemen, please be seated. All right, thank you, Sergeant Brown. Members of the jury, good morning. All right, we've had some business we need to take up, so appreciate you being patient with us with the delay. Mr. Copeland, good morning, sir. Good morning. All right, sir, you're still under oath. All right, Ms. Hilton, you may proceed when ready.
Thank you. Good morning, Mr. Copeland.
Good morning.
You have permission to approach?
No. She was asking me that.
Oh, this was so good. She asked, do I have permission to approach? She's asking the judge. Mr. Copeland don't care. He just says no. He says the state is hiding behind hearsay exception rules. Yeah. If one doesn't work, they try the other and the third and the fourth and everything in between. It shouldn't be allowed because it doesn't apply. It just impeachment by contradiction demands he says something that he did not say then. Just him claiming he lied back then should not, according to case law, give the prosecution the right to play this. Remember, all the times when a cop has been on the stand on cross-examination and the defense wanted in evidence to contradict that cop from something they said back then, something they changed, and the judge denied that. That has happened numerous times in this with evidence that gone missing. They proved to beyond any reasonable doubt about a surveillance camera, a surveillance video, which the prosecution said never existed. And then from discovery, the defense pulls out, here's the camera. Here is the radio chatter where they are talking about watching the surveillance video. And they were still not allowed to impeach the cop on the stand because they could not identify the person on the tape who said it, which is enormously stupid. Enormously stupid. Looking at this now, when the prosecution vaguely says, yeah, he contradicted himself. And the judge goes, yeah, sure.
Mr. Copeland, okay? All right.
Okay.
Councilors, you want to take a look at what counsel for the state is going to show you?
Look at both of those. Looking at 378 Yankee Alpha 1, do you see yourself in this image?
Yes.
All right. And as we talked about last week, you recall going into an interview at the Atlanta Police Department the night that Nutt died.
I don't recall.
Looking at this interview, you see the dates of January 11, 2000 and 2015 on this.
Yes.
You're right, this time the state would like to tender 378 Yankee Alpha and Yankee Alpha 1 on Saturdays.
Yankee Alpha and Yankee Alpha 1.
Yes, Your Honor.
Any further objection to states 378 Yankee Alpha or Yankee Alpha 1, other than has it been stated already? All right.
It's already right there.
I'm sorry? It's admitted and be published as you see fit.
Thank you, Your Honor.
I agree with Ron Bones. I can't believe that Woody is the state's top witness. This is as good as it gets. This is the entirety of the state's case. Woody. Because he is the only one in the entirety of the state's case that can connect any one of the defendants to the killing of Donovan Thomas. This guy is what the prosecution has put all the eggs in the basket for, Mr. Copeland. Because, and you might not know this, but the Donovan Thomas murder, it has no statute of limitations. Most of all the other charges in this indictment, the statute of limitations has run out. But in a RICO charge, they go after what crime has the longest statute of limitation. So thanks to this charge, the murder, then everything else is let in, which leads to a really, really interesting thing here. If the jury comes back with guilty of everything else but this, then they are innocent of this killing. Well, what happens then? Well, what should happen is everything else falls because the statute of limitations has run out. Eve asks, in the Weinstein affidavit, he cites that in the ex parte meeting, the state failed to disclose Brady material. When this comes out, isn't this enough for a mistrial? Yeah, it should be. But Judge Glanville doesn't care. That is why he is holding on to everything until after trial. The transcripts, he wanted to hold on to the transcripts of the ex parte meeting until after trial. Everything is being held on to until after trial.
And Your Honor, we're going to fast forward to 2:59:18 when the interview begins. Or we'll start at 2:58:34.
I got 1 minute. Sure. Yes. Madam, you're playing two, just for the record, you're playing what?
Where we start at 2:58:34.
Which exhibit?
This is 398 Yankee Alpha. 278 Yankee.
Do I need to this?
Can you hear it?
I know you. I know what
If you talk to me ways, how you get my attention?
When you gonna talk, then I'm gonna talk to his family, okay? And let his family put it out.
Samantha Yo asks, do you think they'll ever release the entire transcript, or will courts allow Glanville to redact? Because it's not privileged from what I understand. It definitely is not privileged. And I can say that with as much conviction as I dare to, simply because the judge is claiming attorney-client privilege. Attorney-client privilege only exists if it's a discussion between the client and the attorney. And everything the attorney finds out in preparation. There's so much to it, but I can generally they have to be alone and talking to each other. In that ex parte meeting, you had the judge, the prosecution's team, prosecution's investigators, and security, and the court reporter, who wrote everything down, as far as I know. There is no way in hell or heaven or anything in between that this says privilege. It just isn't. I mean, it's so stupid. Will the judge release the entire transcript? No. I think he will cheat and redact everything that makes him look bad. I think he is that dishonest, because I haven't seen anything in this trial that tells me he's not a genuinely dishonest person, especially after the revelation about the ex parte meeting. I don't put anything beneath him to do, because now he's fighting for his career, his salary, everything. That is what's at stake here for him.
But please speak to him one thing at a time, okay, Kim? One thing at a time, all right? I know, man, it's frustrating. He's not gonna stop, okay? The brother, I don't know what I did to this man, bro. He won't, I've been faithful, bro. I shake his hand like he's old, bro. He's not beating no more, bro. You know what I'm saying? Because that's why we gonna sit down, you gonna tell me what's going on between you and him, and then we'll go from there. Okay? We're gonna have to answer the victim. What you mean? When I go to him, okay? I'm gonna take care of that for you. Like you said, get the family, his family, to tell them to leave you alone. If they ain't got no proof on if you did anything, they need to leave you the fuck alone. Yes or no? Yes. Okay. Right. Today's date is January 10, 2015. Time is approximately 0300 hours at 3 o'clock a.m. I'm here with Mr. Kenneth Copeland. Yes.
If what will happen with everything in that ex parte meeting? What happened was that I made a video about this yesterday or the day before. Georgia Supreme Court told Weinstein that his writ of mandamus is in the wrong court. But in that ruling, they made a few suggestions about this is how the statutes are supposed to read. They were unanimous about this in the Georgia Supreme Court. So what Mr. Weinstein got to do now is file it with Fulton County Court. It will be assigned to another judge. And if that judge says, nothing wrong, they will appeal. Then it's time for the Georgia Supreme Court again. So even if Glanville redacts everything, it should still mean a mistrial, possibly with prejudice, which means double jeopardy applies.
And Mr. Colby, can you give me your date of birth, sir? July 25th, 1991? July 25th, 1991? Yes. Okay. You got it.
Now, I do have to say, these police interviews are really not interested. Mr. Copeland's reaction. Yes.
Follow.
Yeah, but
So the number is not broadcast, and I'm going to move it to 3/12/58.
all right.
Oh, y'all still going?
Yeah, still going? Not a care in the world. Thank you. Yeah, if the writ of mandamus doesn't go well, they have to wait until after this trial is done to appeal. And we are talking about, I think the only person among the defendants who even can afford to appeal this is Mr. Williams, young thug. He's the only one with the means to appeal this. And I bet that the prosecution knows it, and Judge Glanville definitely knows it. He knows most defendants can't afford to appeal. So he's prepared to let it go to the jury, hope for a conviction, and if they do, he will just sit back and still not care, because he knows it's a good 5 to 10 years before this is up to an appeals court. And they go back to watching the video. And here is what Mr. Copeland thinks about it.
And for the record, we stopped at 3/17/11, and we're going to fast forward to 3/17/20.
Say it again. Yeah. Oh,
I just think that court reporter, when she decides to smile, is very, in my opinion, she's quite attractive. Sadly, she sits in a courtroom day in and day out, and that takes a toll on you.
You reached out to your brother earlier Saturday.
And the videos are still not interesting. Let's skip ahead to Woody Show.
The state's going to pause here at 3:32:15 and fast forward it to when Detective Thor re-enters the room. God bless you.
Bless you.
No worries, GD. Thank
We're
you
going to
for being
reshare
here.
at 3:35:45.
Yeah, so I heard. Get Black with me says, interesting. Caliph Adams and a few others rejected the plea offer today. And Jeffrey Winfrey fired his lawyer and is presently seeking counsel. Yeah, the judge in that case had ordered Judge Glanville is ordering the prosecution to give up good faith plea deals. And nobody took them. I think the people who took plea deals quite fast, they regret it now. And out they go.
She wasn't doing yeah. No.
Yeah, sure.
Yeah, we paused it around at 3:48:08.
And Woody ran out of courtroom because he had to go pee. And how about that, folks? What does that look like? What does that look like? It is a sidebar counter. It is sidebar counter 214. Oh. Sorry, folks. Sorry. Let's do one of these things. I haven't done this in a while. Yeah, folks. This channel is being kept afloat thanks to a few bucks in ad revenue and your generosity. With a super chat, gifted membership, or via PayPal, you can support this channel. Becoming a member is $3 a month, and it gives you all the members-only content you will ever need. And a super chat if you really want to say something at the same time as you want to sponsor this channel. And via PayPal because you don't want to sponsor YouTube with 30% of what you gift. So, if you wouldn't mind helping me keeping this channel afloat and keep prospering, not necessary. Don't give what you don't have, but if you have, don't be scared to sponsor this show. Thank you. Skip ahead.
Across the building here. So a chiller or something like that is malfunctioning again. So bear with us, okay? All right. It's working some. They tell me like 70%, but this doesn't feel like 70%, does it? Nah. Okay. All right. Ladies. And then we'll come back, see where the afternoon leads us, all right?
And then they have recess.
Okay. All right. Starting seminar, jurors, please.
And after lunch, they have Sidebar counter 215. Oh.
I'm going to call our jurors out in just a second, but it's just, I was speaking with counsel. We have somebody that may have tested positive for COVID this morning. So if you want to wear a mask, you're certainly welcome to do so. I'm going to put one on in just a second. We have masks available for your use if you'd like to. So with that, if you need one, let us know. We'll go ahead and have you wear one. Okay. All right. Mr. Ms. Hingerty, your client probably needs to wear a mask. Okay. Say again? Yes, ma'am. Thank you.
I came down as you know.
Yeah. Yes, ma'am. Okay, sorry, name all our participants here? Okay, all right. All our jurors present? Okay, let's bring our jurors out, please.
Thank you so much to Vintage CB, gifted 5 memberships. To Robert Libby, Siobhan, Eve, Ron Barnes, and Gwendolyn. Welcome and welcome back as members. You now again have all the members-only content you will ever need. And my members-only content is less of law and more about me, so we get to know each other better. It's the farm, it's the renovation, my personal thoughts, some dad jokes and stuff like that. So thank you so much, Vincent CB, for your generosity. Thank you so much.
Miss Westmoreland, do you need a mask, madam? Okay. Mr. Kokomo, do you need a mask, sir? Anybody else need a mask? Mr. Matthews Jr., you have one? Okay, Ms. Hingerty has one? All right. All right, ladies and gentlemen, please be seated. All right, thank you, Sergeant Ingram. Ladies and gentlemen of the jury, I've told everybody already, and I think you all must have gotten the memo already. Somebody in here may have tested positive for COVID exposure, so in the abundance of caution, we have issued masks to everybody. I would encourage you to wear them for the rest of the afternoon. I'm going to have the courtroom deep clean this evening, and your space in there as well, and we'll just drive on, okay? All right. Ms. Hilton? All right.
We will resume playing State's Exhibit 378 Yankee Alpha at 4:05:58.
We got the same interview with Mr. Kenneth Copeland. We give information in reference to the homicide investigation of Mr. Donovan Thomas. It happened at 330 Main Street, Southwest. Atlanta Police case number is 150102106. Today's date is still January 10th, 2015. Time is approximately 4 o'clock a.m., which would be $400. Okay. Mr. Cole, go ahead and tell me what you just advised me of in the office. And you can, sir, you be in detail about what was going on today and every event that happened today. Okay. Okay, I left my girl's house. My brother gave me the car. So my brother gave me the car. I had to put up in the candy bill. The girl, she gave me a little bandage for my mouth. And I put out a little something on my mouth. I left there. I went on Cleveland. I was with Lil D. Pick up Lil D. You know what I'm saying? So Lil D was like, hey boy, they say nothing, you got shot. This first thing he said, like real, and then he was like, yeah, we talked. So moved to FaceTime me, and he was like, he told me the same. So I was like, well, I just heard it, he just told me. So he was like, yeah, he's like, you know the name is Stream. So I'm like, who? I like, yeah, you know, I already know. He's like, yeah, but even he got shot, so one thing was a big deal. So like, all right. So moved to him, like, he could come out. I was like, all right, call me, you come out. So I got the phone him. So I took the D down to the whole house. I'm gonna scream my name to the girl house. I done got this young. I put up at Jojo's house. I called her, she came out the door, she got out the door. I said, hey, where does Jojo live? She said he's on Metro Park behind Chevron. That's a little apartment. Okay, quick. So when I looked at this son of Jojo's house, I told you they son like they say nothing got shot. And she like, for real, the one him and her dad know each other. She like, yeah. I said, they said I did. Like everybody on Twitter like already met. So I'm telling her like, damn man, like. So she like, what we gonna do? I said, man, do I talk to the police? She like, okay, this is me and this young about. But I had made her roll out. She said she wanted to have me. She ordered food. She got food. So we were going to my brother's house because I was going to talk to my brother about that. I sent him tickets. And then when I get to my brother's house, I'm turning left into the apartment. He said, where do your brother live? Come home. I'm already having. I'm turning left from Peru to the inside the apartment where he stayed. I see this Camaro flying out. But when I turn left, the Camaro, like, they go straight. And then I go, instead of going in front of the door, I went around to the gate. So as I go around to the gate, I had the wrong gate color. So the gate color was to this son's apartment. So as I was kicking, it went over upside the head back to go park around in the front. Because I was going to tell my brother to call the police. So as I did that, I see the same Camaro flying to the stop sign, but it was going to stay there and miss it. And they turned left behind. Like, when they turned left, I was in front of them. So I went to the stop sign, made left. When I made left, I went to the next stop sign, I went to the next stop sign. There's 2 more cars flying in front of me. But they made the left coming down Front Road and to the front of me.
I mean, this is still isn't fun. So let's try to find where we can go to.
It's down 0418 hours, be 4:18 a.m. Include no statement from Mr. Kenneth Cole.
Yeah, isn't that weird? The state argues to the court that there is no notes of any of this. He's writing something down, but according to the prosecution, no, doesn't exist. And the judge agrees with them. There exists no notes.
But deal with the homicide investigation, Mr. Donovan Thomas. Letter police case number is 150102106.
Your Honor, state will conclude playing at 4:18:08.
You want to speak on that one?
Your Honor, next we will tender State's Exhibit 378 Yankee Charlie.
Any further objection to State's 378 Yankee Charlie?
Which date is this? This February 20th?
Yes.
It's a-
Same objection.
It's admitted over objection and maybe published as you see fit.
Thank you, Your Honor. Court's indulgence. Permission to publish, Your Honor.
Yes, you may.
I can't say anything against it. Against Councilman Couch, who have heard from reliable sources that the officer was writing down at what time his wife's boyfriend was coming over. I have nothing to say it's not true. Still not interested. So let's go through. See if we have more courtroom. Oh, they went on a break. Let's see if we missed something.
She went.
Ah, this is so dishonest from the prosecution. That square there is to protect the other person in that room, the girl. But as you saw, they showed her anyway. Yeah, and they're on a 15-minute break. Then they come back.
The defense.
Sure. All right. All right, sir, name some of our jurors, please, sir. Mr. Copeland. Mr. Copeland. All right, ladies and gentlemen, please be seated. All right, thank you, Sergeant Ingram. All right, Ms. Hilton, you may proceed when ready, madam.
Sorry. Thank you, Your Honor. We'll resume playing at 2:43:14.
All right.
Hold on, this is hold on, hold on. Hello? Where y'all at? Yeah, yeah. How long did it take? All right. Mom. Tell your number. Yeah.
Yeah, I skipped through that.
We're gonna publish State's Exhibit 324Y.
Hey, Larissa. No worries. You are not missing anything. Play it in 1.25 and you will catch up in no time.
Mr. Copeland, on the screen is 324.
It's already been admitted, madam.
It's already been admitted. Your Honor, it looks like there's something happening with the Zoom. Please. Our screen is blanked out and this screen over here. Are you everything on? Those screens are still working, so it's only a few screens. Oh, Your Honor, every time we're trying to publish something, it's restarting everything on our Zoom. And it's happening with each of our computers, Your Honor.
Let me see if Ms. Amon can add you all again, okay?
Okay.
Because it doesn't seem like any of you were here or any of you were. Just in recess in place and call her.
Thank you, Your Honor.
All right. Now they are going on recess. Something like that. Yes, CC. Needs to see the real Kenneth Copeland, the farting preacher here on. Okay. Now we have seen Judge Gavil fart in court when he thought that his mic was off. And it wasn't.
Your Honor, given the state's announcement to the court earlier.
Would this be a place to stop?
Yes.
Okay, all right. Ladies and gentlemen, this might be an appropriate time for us to recess for the day since we had, I've had a conversation with counsel. This might be a place to stop. So we're going to go ahead and just recess you till tomorrow morning. You'll need to be here for 9:30 for anticipated 10 o'clock start time. And tomorrow we will work from probably about 10 or 10-ish to about 2. And that'll be the extent of our workday. Okay. All right. Mr. Copeland, we'll see you tomorrow morning at 9:30. Okay. All right, thank you, sir. Ladies and gentlemen, any ministerial inquiry of me at this point? I apologize for the heat. I have arranged for our space to be deep cleaned. That will occur after we leave for today. Okay. So, and then more updates as of tomorrow. All right. Okay. So unless you have anything in ministerial nature of me, let's review. When you go back to your headquarters, do not leave your notepads in the basket. Do not have any conversations one way or another in ones and twos, or as you go to any other place, or you sit back in there, wait on us. It would be a violation for you to recap, handicap, or otherwise review the testimony or review your notes with each other as you have not begun to consider this case in the manner and fashion that the court will instruct you on when we get to that particular stage. So it will be a violation for you to engage in any of those particular activities. Remember, ladies and gentlemen, you are not permitted to go to any scenes or any locations that you may have heard testimony on thus far. Remember also, it will be a violation for you to go to any of those places and either draw, take photos, or discuss with your colleagues in the back any such knowledge you may have of any of those. You can only consider what's been presented within the four walls of this courtroom. In that respect, ladies and gentlemen, remember you're also not to go to any third-party sites, any consulting what you consider yourself and start your All right, ladies and gentlemen, please be seated. Our jury has left us.
Damn. These last 20 minutes, now it gets interesting.
All right, Ms. Hilton, what other business, if any, do you need?
Yes, he actually did fart near his mic. Hold on, and I will get it for you. Hold on. Dun, dun, dun. Where did it go? It's been a month and a half or something like that. There, let's see here. I did a video on it. Hold on. Hold on. You all know how sometimes you just have to let off steam. That you can't really hold it in anymore. Well, on day 68 of the Young Thug trial, the judge decided to do just that.
Interviews, okay? That was her testimony on the stand. I am telling you as an officer of the court, and I think everyone on this side is in agreement. I believe the state's in agreement. And the discovery provided.
Let's hear it again.
About those interviews, okay? That was her testimony on the stand.
He leans forward
I'm
and
telling you as an officer of the court, and I think everyone on this side is in agreement. I believe the state's in agreement.
Yeah. Yeah. General advice, folks. Don't force a fart. It might become a shot. Yeah, I feel sorry for the service dog as well, who has to sit behind the desk, breathing all that in. Oh.
You take up with court?
Your Honor, if defense counsel wants to provide to the state for at least the January 28th and February 21st interview,
So January 28, 2015, and
Yes.
February what?
21st, 2015 interviews, the portion that they think could be needs to be redacted, they can get that over to us this evening. We can look at it and I believe, hopefully determine which ones we agree with and then only have to litigate over that we do not agree with.
All right. Okay, counsels, and for the defense, any issues as to relates to what the state's proffer is? They're gonna currently send you the redactions for the January 28th and February 21st, 2015 interviews.
No, we were hoping that they would send us what they believe should be redacted.
Okay. Do you have what you would consider to be subject to redaction, Mr. Sharp, or any other counsel?
I personally have not.
I apologize. Sorry, I apologize. There's a coworker of mine outside, and I understand the sheriff deputy said court's over, so no one can come in. I don't think that that's the rule, so.
Which coworker?
Now, thank you, sir.
Okay, all right. Okay, all right.
So, as I understand it, the order that the state is proposing is the January 28th and then the June 10th.
January 28th and February 21st. And if we're only going until 2 tomorrow, I think those would be the only ones we would
Okay.
get into. And then June 10th will probably be on Thursday.
Okay, I have been putting my efforts into June 10th. But we can work on, now, does the state have any proposals? The state has given me proposals for the June 10th redactions. Does the state have any thoughts or proposals about the 2 that they're planning on going into tomorrow?
We don't, given what his testimony is, we intended to play the entirety of it. There may be 1 or 2 issues that we'll review again, but we don't have any. But if there are some that defense would like us to look at, we would, like I said, look at them and review those.
Okay.
I will talk to my colleagues and we will get back to the state as soon as we have an answer.
How long is the interviews on the 28th of January and February 21st?
January 28th is approximately a little shy of 3 hours. And February 21st, roughly around the same time, a little bit shy of 3 hours.
Hey, Christina.
And can you tell me the June 10th of what year interview?
2015.
June 10th, 2015 is 9 hours in duration.
Okay.
Ultimately, does the state plan on playing also the 2021 statement?
We probably will, but it depends on how the questioning goes with Mr. Because we have not broached the October interviews yet with Mr. Copeland, so it would depend on what his testimony is.
All right. But at least these three, you're planning on playing in some particular form or the other.
Yes, Your Honor.
All right. Have you identified any other than, well, have you identified those portions that you believe to be objectionable on either the January 28th or February 21st interviews, Mr. Sharp?
We have not identified giving them to the state. I'd have to check my notes to kind of remind myself of the work I've done in the past. But let me just, before we go too far down this road, let me just say that on behalf of Mr. Stillwell, I'm maintaining all objections to lack of foundation
Sure.
for prior inconsistent statements and hearsay. So I'm
gentleman,
answering these questions,
yes.
but I don't want it to be perceived that I'm waiving
No.
that argument.
I think that your position's been made very clear, and I'll of course listen to any objections you may have, in addition to the ones that you've already made that you'd like to recap. But what the court's just trying to figure out is whether or not you've identified those particular sections that you know that you would need, that the court would, that you would need to be, they need to be redacted or otherwise omitted.
I believe when it comes to the February 21st statement, which I just listened to the other day again, I think that there's going to be less of that matter, less of the objectionable material in it than the January 28th. That's going to be more of an issue.
Okay. What about the January 28th?
I'm going off of memory because there's so many statements, but I believe that that's one of the more wide-ranging interviews where different topics are discussed and hearsay matters are discussed and speculation and all of the rest.
Don't go anywhere. Does anybody else have any comment on the 28th of January or February 21st interviews? Have they reviewed any of them? Do they wish for me to be heard on that issue? Mr. Steele?
I do. Sir, I don't believe that the burden should be on Mr. Williams to send the state what we believe should be redacted because the state's the one trying to introduce the evidence. And there are parts of both of those statements which I have gone through and I have delineated much of these topics or these recordings that should be struck. But I like some of the stuff that I've struck. So if the state doesn't strike it, I just won't object to it. But I don't believe that I should go first and have to do that work. So I asked the court to do what it originally said and ask the state to furnish the accused, and then we can rebound from there. Now, if that's in contrary to the way Mr. Sharp wants to do it or anyone else, I will bow down to them. But otherwise, I believe that that's the proper procedure. And the reason I say that is because if I was trying to introduce an item, I don't just take the item, which I know has to be redacted, and say to the opponent, hey, here's everything. And then you tell me, and let me see if I get something that I like in because you don't catch it. I don't think that's how it's supposed to be. So I think a good faith belief and redaction by the state needs to be done first. And for instance, and I know we objected to it, but now that you heard it, I'm assuming you didn't hear that recording from February 20th, 2015. That is State's Exhibit number 378YC. And just, it's just obvious even to a casual observer that the police officer was speaking a great deal, talking to Mr. Copeland, saying, this is your first child. Do you think you'll be able to see your child grow up? I know you had nothing to do with this. You were defending yourself. That should never come in. And that's what we objected to before. And that's why I think that the state has to say, just like you started to this morning, why is it a prior and consistent statement? Why is it contradictory to the testimony? And then you can play those portions, but you don't just get to, I don't know what the expression is, throw away the bathwater with the child or throw away the child with the bathwater, but that's what it appears to me. So I have those two items that I'd like the court to consider.
Okay.
To answer your question directly though, yes, I have done it. I do have redactions, but I don't think that it's right.
Okay. The court's concern is that given, I'm in concurrence with that the state needs to provide you with the redactions and you all can go through it. My concern is it worth us bringing the jury tomorrow? That's my concern, is that might as well, if you all are going to, if I'm going to have to weigh in on the admissibility of various statements from the 28th and of January of 2015 and February 21st of 15, then it might just be more appropriate to let our jurors just not come in tomorrow and have them come in on Thursday. The other thing that I'm of the opinion of is that before I go ahead and go forward with that, has the state identified redactions for June 10th of 2015?
Yes, Your Honor, we provided the June 10th ones yesterday evening, and then we resubmitted them this morning when we learned that.
Okay, so it's possible maybe I can go through the redactions, at least in some particular order for tomorrow, tomorrow, and then our jurors can listen to whatever it is they can listen to on Thursday. Friday, as you recall, or just to remind you, is an administrative day for you all. Are there other statements that you've identified, Ms. Hilton, and that you're potentially going to have the defense look at?
So the only other matter, Your Honor, would be jail calls. So we provide a defense counsel with about 11 jail calls that we intend on using. And so that would be it. So it would be these 3 interviews that are left, potentially 4, but that depends on Mr. Copeland's testimony, and then the jail calls.
Okay. How long are the jail calls as a collective group?
They're 11 and 15 minutes, so
15 minutes each?
yes. So roughly 150, about 2 hours.
2.5 hours, two and a half hours?
Yes.
All right.
Dun, 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 dun. All right, let's move on to day 94. Let's see, there it is.
Okay. First order of business the court needs to take up this morning. I have 2 motions to recuse, one filed by defendant Jeffrey
Here we go.
Williams that was filed yesterday and handed to the court at the end of the business day. Another one has been filed under the same indictment, just indictment 22 SC 183572. And I want to say that motion to recuse has been filed on behalf of Ms. Caleb Bumpus. Can I get the lawyers for, or the principal lawyer for that particular case to identify themselves for purpose of the record?
Judge, good morning, Dave Banks.
Good morning, Mr. Banks.
Her legal team is also here. Mr. Collins, Ovey this morning, and Mr. Winchester.
All right, good morning, councils. Okay, as it pertains to your motion, Mr. Banks, and on behalf of everyone that is here, I'm going to just take up the issue of the recusal. I'm going to defer the issue of the motion to quash at this point in time, okay? So I'm not going to take up anything. I can't do it anyways because the rules require me to go ahead and deal with the motion to recuse to begin with. So I've ceased any other business, and that's why I had Mr. Chamberlain reach out to you last night and counsels for you all to be here this morning so I could take this up. Your motion actually was filed last Friday at 10:40 p.m. It didn't appear in the system, however, as sometimes odd.
Yeah, this is two motions for him to recuse himself. One by Miss Hobart, Bumpus, and because this is interesting. Now we are getting to interesting parts.
See, it happens until sometime on Monday evening. So when I started to read Mr. Steele's affidavit last night, we were put on notice that there was possibly another affidavit out there and another motion. So that's why we had to call you. Okay. So that's how we got here with this. Or else, did you all attempt to send me independently another a copy of that, or?
We did not, Judge.
Okay. No harm, no foul. No. So I just wanted to know if you had attempted to do so, because we would have certainly, had we known that, pulled you in on Monday morning, which would have been the closest time that I could have heard your particular motion. So just from a time aspect, I just wanted to account for that. Taking a look at this applies to both motions that have been filed to recuse the court or disqualify the court. Recusal by a Superior Court judge is governed by Uniform Superior Court Rule 25, etc. Rule 25.1 provides that all motions to recuse and disqualify a judge presiding a particular case or proceeding shall be timely filed in writing, and all evidence thereon shall be presented by accompanying affidavits, which will fully assert the facts upon which the motion is founded. Filing and presentation to the judge shall not be later than 5 days after the affiant first learned of the alleged grounds for the disqualification, and not later than 10 days prior to a hearing or trial, which is the subject of the recusal or disqualification, unless good cause be shown for the failure to meet such time requirements. And that is cited in Georgia Uniform Superior. Applying that to both sets of motions to recuse. And applying this rule, Georgia courts have held that when a motion to recuse is filed, the trial judge shall immediately, 1, determine the timeliness of the motion, 2, the legal sufficiency of the affidavit, and 3, the legal sufficiency of the grounds, and has no power to do anything else. And that is Robinson versus the state, 332 Georgia Appeals at 240-241. The 3 threshold determinations that the trial judge must make in regard to a motion to recuse are whether it's timely filed, whether the affidavit made in support is legally sufficient, and whether some or all the facts set forth in the affidavit are true, recusal would be warranted. And that is Dacker versus the state, 300 Georgia, 74-77, 2016. The judge finds any 3 of the conditions have been met. No, I'm sorry, take that back, strike that. If the judge finds that all 3 conditions have been met, he must refer the motion to another judge to hear the motion. But if any one of the conditions is not met, there is no error in denying the motion. And motions to recuse are viewed and considered by the appellate court for abuse of discretion. Accordingly, the court is going to address each one of the factors as it pertains to both Mr. Steele's motion and, for shortness, Mr. Banks' motion. I find both motions were timely filed. I find that Mr. Steele's motion was in fact filed on this past Monday, which would have been the 17th of June. I find that Mr. Banks' motion on behalf of Ms. Bumpus was timely filed, as it was filed on the filed on the 14th of June at 10:40 p.m. Secondly, I find that in addressing the legal sufficiency of the affidavit, that means, was it sworn? Was it sworn before a notary is in proper form? I find Mr. Williams and Ms. Bumpus's motions to be, or I should say affidavits to be in proper form. The third thing that the court has to review, and like I said, I reviewed, is the legal sufficiency of your grounds of the motion. And
He almost gets it right here. But he knows.
And here's
he applies the correct statute, the correct law, the correct rule as it is written. He cannot make this ruling. We saw that in the Georgia Supreme Court when they denied the writ of Mandamus because it was filed in the wrong court. They explicitly said in that ruling that Judge Glanville can't make this ruling by himself. It has to be done by another judge. But Judge Glanville is too invested in this. He wants this trial to go through to the jury. He desperately wants this going to a conviction. He is doing everything he can because now he already knows he overstepped the boundaries. Judge Glanville, from the point of the ex parte meeting, probably long before that, but provably at the ex parte meeting, committed criminal acts. What he's doing there on the stand is criminal, in my opinion. Thirdly, there's a thing called it's prosecutional immunity and judges immunity and everything in between. There's so much immunity to these corrupt players in this trial.
where the court finds that upon a review of Mr. Steele's motion and affidavit, as well as Mr. Banks' motion and affidavit, that both contain assertions bare assertions and legal conclusions which aren't sufficient for the court to grant your motion at this point in time and refer it to another judge for it to be heard. So I'm going to deny the motion at this point in time. I invite you all to look at Baptiste versus the state. Just because adverse rulings have been made doesn't mean that the court stops the trial. So I'm going to make that. I'll reduce both of the motions to recuse to an order, and I will file that so you can take whatever steps you need to necessarily after that. But I don't get into anything about the affidavit itself, argument on that. I just have to read it. Those are only three things I do. And then if I find it to be not sufficient on its face, I go for it. I just make the ruling at that point in time, let you all take it up. No, I won't grant a motion for a certificate for immediate review. And that's where we are at this point in time. Anything else, Mr. Banks?
If I could just briefly be heard, Judge.
Sure.
And I'm not trying to, I understand the court's ruling and we'll proceed as we see fit. I do take issue with the court's characterization about the legal insufficiency of the affidavits.
Well, that's why when it was reviewed on appeal,
Sure.
it can certainly be, I mean, the appellate court will review my ruling for abuse of discretion.
Certainly
Okay.
understand that, Judge. And in stating that, Judge, I would just say that one of the issues that is raised in our affidavit, because our motion to recuse is to recuse you from the contempt proceeding, not the underlying criminal case in which Your Honor is presiding. And so we really don't have an issue or standing to even challenge that. And so to the extent that there is a contempt proceeding that is set for the 25th, Your Honor, you are a witness to that proceeding. And so because you were a witness.
I don't believe you. Well, I'm not going to get into any argument. I can't. So that's your assertion at this point in time. And like I said, when that is taken up, I'll consider. I also remember I still need to rule on the issue of the motion to quash. So I may, depending upon what I decide to do at that point in time,
Sure.
Other things may be right. Okay.
Do you want to hear about the motion to quash or you want to take?
No, not yet, sir. I'm going to take up the motion to quash after I finish we finished the direct of the current witness.
Okay.
And to other issues that have been raised, as I've told some of the other lawyers here, there is a transcript of what occurred in the ex parte matter. I will, in fact, I'll authorize defense counsel. I'll do a privilege review and see what needs to be disclosed in terms of impeachment and or Brady. And for that, and I will do that. And then so if that pertained or if that issue affects you, then certainly that may be something that at the appropriate time you'll be able to have a look at.
Well, I appreciate the court's time. We would certainly rely upon our brief and our motion, and that's a part of the record.
Okay. All right. But I will reach out. The court will reach out to you on two things. One, the ability to take a look at the ex parte transcript and review it for the appropriate parts that the court will authorize. And then also for the, I'll re-note you because I know that it's supposed to be done this Tuesday, but I doubt that we'll probably have it this coming Tuesday.
If I just may say, again, Judge, I know I've already said it as it concerns the issue about you being a witness to the proceeding. We don't believe that that's a bare allegation. We believe that would be an established fact at the hearing. We also,
but I can't take it. It's not something I can argue with you at this point in time.
See how the judge wants to have the cake and eat it too? He's using both things. He claims he can do the hearing, he claims this, he claims that, but when asked about the specifics that actually makes him a witness, I can't talk about that. And he doesn't allow people to get things on the record by interrupting them all the time. I hope that Weinstein gets the writ of Mandamus to a superior court in Fulton County before Monday or Monday, if he hasn't filed it today. And I really hope he does. So for the sake of everything, so this trial can end, because this is so stupid. Hi, Dali.
and I'm not trying to argue.
No, sir. You are an advocate for your client. Sure. That's the only thing I can say, but I'm not going to take up that issue right now. It's part and parcel. You've made it part and parcel of the motion to recuse. So I'm saying that at this point in time, I've made my ruling. You've said what you need to say in terms of what your thoughts are. I'm going to reduce it to an order, and you can take what you want to after that. Okay.
All right. Thank you.
All right. Thank you, sir. All right. Mr. Steele, similarly, I'll reduce what I have mentioned to in an order, and you will be able to take it up as you see fit. I'm not going to grant a motion to a certificate of immediate review.
Stacey Lane, we got an idea of what happened in the judge chamber. The judge and state won't be able to hide it for too long. There's too many witnesses. And everybody have a lot to lose by protecting the judge and the prosecutor. A lot of people have a lot to lose, especially the court personnel. There's simply no way to hide this for too long. And remember that Ms. Bumpus was in that ex parte hearing. She will testify about everything under oath. Everything. Yeah, this show cause hearing, she flew in from Ms. Bumpus flew in from Texas, and the judge rescheduled it. It's he's so bad.
Anything else?
I have read Baptiste versus State. I've read all the cases that I believe are applicable. I'm, best I can. But specifically, if the court would reconsider, and if nothing else, the Honorable Keith Adams and my joint affidavit in paragraph 12, we assert not a bare assertion or a legal conclusion, but we make facts that we specifically adopt from the Honorable Attorney Winchester Collins, Banks, Nove, and Mormon's motion where a person that they represent was in a meeting ex parte with the court and others and the prosecutor and a witness, and specifically they wrote in the pleading and under Parish, which is P-A-R-R-I-S-H versus State, which is 362 Georgia Appeal 392 Division 1 2022, the lawyer's pleading on behalf of the client becomes a statement of the client. And they said that this court got involved with speaking with Mr. Copeland and assisted in Mr. Copeland testifying against Mr. Williams. So I've added this court to the witness list. I plan on calling the court as a witness in the trial. I added lawyers Hilton and Love from the district attorney's office to the witness list. And when I cross-examine Mr. Copeland, when that day comes, I'm going to ask him about how much pressure, if any, the court put on him. And you're going to be the one instructing the jury. And I just can't imagine how that's fair to Mr. Williams. So I just ask you, I'm not abandoning anything in the joint affidavit from the Honorable Attorney Adams and myself, but if you would just look at just even paragraph 12, again, if you didn't consume it entirely, I don't believe that meets a legal conclusion or a bare assertion. I ask the court to recuse.
I've read your affidavit, Mr. Steele, and I've consumed everything on it, and that doesn't change my ruling at this point in time, respectfully.
I also, on the transcript, I'd like the recordings and the transcript, and I object to the court going through it and deleting, because to me, the way I understand it, there is zero privilege. So I don't understand.
Yeah, this is Judge. I've been through this before, but if you haven't seen my reaction to it, I get equally pissed every time I get to this part. Equally pissed off. Because Judge Glanville is actively hindering justice in this point in time. Actively. His claim of privilege is simply false. It's simply false. Judge Glanville, at this moment, is lying on the record, misrepresenting what was going on, misrepresenting the law. It is infuriating. He's been a judge for 20 years and a brigadier general before that. Judge Glanville has no morals. He's morally corrupt. Completely morally corrupt. And that puts into question everything he has ever done as judge. Everything single decision he has made are in question. Because here he clearly knows, without being faced about it, he's lying on the record.
I'm not gonna, Mr. Steele, I can't argue with you about anything such as I've made my ruling, okay? If you have some other basis to ask for the recordings or anything like that, you're gonna have to put those in some other pleading. But at this point, Ms. Weaver's gonna prepare the record. She does that. And like I said earlier, the record should be ready soon. And you all, as a defense group, will have the opportunity to take a look at that particular ex parte transcript that was done in chambers, less anything that is totally that the court considers to be privileged. And I'm going to let you do that before you examine Mr. Copeland. So you'll have everything that you have at that point in time.
Thank you.
All right. Okay. All right. Let's turn now to the statements or interviews from January.
I have to interrupt the court. That finishes our business today, man.
You don't want to stick around?
No.
Okay. Well, okay. Thank you, Mr. Banks. At all. Okay. All right. Okay. Yes, you may be excused, sir. All right, Ms. Hilton and counsels, what matters do you have to take up from the interview from the the January 28th, 2015 interview?
Your Honor, last night we sent over both the February 21st and January 28th redactions. We sent the February 21st one around 7 p.m. and then the January 28th, probably around 11:30. We have not heard from defense counsel yet, so I'm not sure if they've reviewed them and if they have any additions or disagreement. So we were just waiting for defense counsel to let us know their position.
Okay. Counsels, for defendants, have you identified, since now the state has sent you parts from the 28th January interview that you wish us to talk about? Mr. Sharp?
Good morning, Your Honor. I have not had a chance to digest their proposed redactions. I'm happy to talk to them about it. I've been working feverishly on getting together the redactions that we believe are warranted. Again, I'd be happy to talk to the state about that. I'd also be happy to go through them one by one with the court, however is favored. But I can't say at this moment that we've cross-referenced the two lists.
Okay, all right, so that's what we're supposed to do this morning, though. So does anybody else have flagged or wish to be heard on the interview for January the 28th? Sure. We're going to cover them independently. Like the January 28th, we'll cover the February 21st, and then we'll cover the June the 10th interview, and then potentially the jail calls.
I believe that myself and Attorney Steele may both have lists. I don't
May have what? Sorry, I'm sorry.
Lists.
Okay.
But we're representing different individuals, so the list may vary a little bit. So you may be getting some suggestions from this chair, some suggestions from that chair, and then some suggestions from the state.
I understand.
Yeah. Okay. Your Honor, may we have 15 minutes to just talk to the state about their list?
Yeah. Does anybody else have any statements that they've identified from the January 28th or February 21st or June 10th, other than Mr. Steele or Mr. Sharp, that they want to bring up?
Yes, folks. At my place, where I am streaming from, it's 9 p.m., which means the wheel of regrets is in effect. The wheel of regrets. If you don't know what the wheel of regrets is, it is this. This is me at every $50 in super chats, gifted memberships, or via PayPal. I will spin the wheel and do what it says. Now, this is just pure entertainment and a bit of a grift. Because gotta make money somehow. So, for instance, if we had reached $50 now, this would have happened. I would have spun the wheel and taken a gin shot. Now, the gin is not any gin. It is a Navy strength gin at 57%. All right. So that is in effect. We have a couple of hours, at least, more of checking what's going on in this trial, because they kept having hearings about these damn videos, and it gets more and more infuriating and more stupid.
All right. Okay. All right. Then I'll give you all 15 minutes, and then you can come back and we can just begin with the 28th of January interviews. Okay. All right. Wes.
They went on a break. And the break went on and on.
Okay. All right. Okay. All right. How much longer we all need?
Well, I
think that Mr. Sharp just represented that they haven't had an opportunity to identify, or to review the redactions. I'll let him speak for himself.
All right, sir.
Not quite what I said. We've identified things that we think need to be redacted. The problem, the mountain we're climbing is both sides have their own transcript and the pages are not the same. So we're working off two different transcripts, and we have converted our files to MP3. They're still going off an evidence reviewer. So we're working off two different transcripts and two different videos with different timestamps. So we've figured out a system to try to make it work. It's just a little bit time consuming. So we're working on it. We have identified, and we're going to get to the state what our proposed redactions are, and we still have to cross-reference their redactions. So it's just a time-consuming process.
Okay.
We're working as quickly as we can.
If they have redactions that they have identified at this point, and they would like to turn them over so we can review them, and if they turn over both the transcript that they are using and the MP3 file that they are using, that corresponds with the redactions that they've requested, we could review those. We could at least be reviewing those while they're correlating the ones we've given them to the media that they have and the transcript that they have, so that the downtime isn't a total wash, and we'll be able to make some kind of progress.
All right. Sir.
I will see if we have, we should have a copy of the MP3s. I don't think we have a problem with that, but we'll figure out a way to get them the information so they can reference their materials so they can see what we're suggesting.
Okay.
And we can literally listen to it in their media format, however they give it to us, and we can know whether we agree or disagree with it in the format that they have it right now.
Okay. So how much longer will you all need?
Well, we are nearing the end of the January 28th statement. I don't anticipate the February 21st will take us quite as long. I anticipate the June 10th will be very lengthy. So if you're asking to address those two statements, I think that we could be ready in by 45 minutes to an hour. But regarding June 10th.
Okay, well, let's just bifurcate it. As you all told me before, the June 10th one will take the longest. So, but you have identified most of those statements. Is that correct?
In June 10th?
Yes.
Yes.
Okay. All right.
And the good news about June 10th is we're actually working on the same transcript on that.
Okay. All right. So do you all want me to give you another 45 minutes? Let's say we recess and have come back at 12:45?
So we'll be discussing the January, which ones will we be discussing?
January 28th and February
21st. At a minimum.
Okay.
Yeah, I'll have to, we'll take up the June 10th one. I had planned on, once we kind of finish those two, we can kind of get an idea what would be an appropriate schedule. Okay.
Yes, John.
All right. That work for everybody else?
Yes, it does.
Okay. All right. All right. We'll see you all back at 12:45. Okay. All right. Okay. More recess.
I didn't know Ashley was pronounced differently. It's not Fanny, it's phony. Okay, phony. Here's the thing. I'm Swedish. I have an accent. It's either Fanny or phony. Both applies. All right, and then let's see here. They are back a bit later.
Defense counsel's redactions.
Yeah, some of these days, not much happen. Oh, Ashley Merchant. Oh, I like her. She's really good at her job. It's Fanny because she acts like an ass always. Yeah. The fun thing about Fanny is that in Europe, well, in the United States, Fanny is the back end. In Europe, it's the front end. So her parents named her after the entire undercarriage of a woman.
All right, councilors, where are we at this point?
Your Honor, we just received defense counsel's redactions. However, their redactions are in using an MP4 format. And so we need to convert it to evidence reviewer so we can know exactly what we're talking about. To answer the court's question, the state isn't ready at this juncture just because we just received it. And so we need to compare what they're asking for and see if it even lines up with what we gave them, because it appears that some may overlap. We just have not had the opportunity to sit down and compare our two lists. And so we would need time to do that.
Okay. How long are you gonna need to do that?
I'm not sure if the court was still leaving at 2, but we probably would need at least an hour, if not more, because again, they gave us about 13 periods of redactions.
Okay.
And so we need to play and see what time those are. So it's going to be a little tedious of a task to do. And some of them may correspond with what we gave them. We're just not sure at this time.
All right. Mr. Sharp, do you have something you wanted to add? Or Mr. Matthews? Yeah.
So I believe Mr. Kokomo is copying the MP4 video for the state, so our timestamps make sense. Is that correct? Yes. Okay, so we're in the process of doing that, and we have to check behind using a different, what the format that the state was using. We have to go into that format to look at their redactions. So I think both sides are solid on what their own side's redactions are, and now we're entering the stage of checking the other side's redactions, proposed redactions.
Okay, all right. Mr. Matthews, anything? Did you stand? Okay, all right. All right, all right, well, you all can continue to work. I'll check back with you all at 2:10. And I have a unrelated meeting at 2:30, and we can see how much we can get done after that. All right?
Yes, Your Honor. Thank you.
All right. So we're not gonna be leaving today at 2, but we'll see what we can get done. And then that will also dictate whether or not I need to take some more time before we call for our jurors. Okay? Just depends on what we get done.
Yes, Your Honor.
All right, okay. Anything else? Okay, all right. All right, we're in recess until 2:10. I mean, it's at 2:10. I'll check with you all at that point in time.
Check. All right, thanks.
Let's skip to the next time. There it is.
States proposed round.
I believe Mr.
Recordings from January 28th of 15 and February 21st.
So, Your Honor, I don't believe we've even started on the 21st yet. However, for January 28th, I have 6 more redactions to confirm. And I believe Mr. Shard says he has 9 more.
So I have some good news and some okay news. The okay news is we're not quite done. We're on 11. We finished 11 out of the 17, reviewing 11 out of the 17 states' proposed redactions. I can say in the state, 1 we're okay with, 2 we're okay with, 3 we're okay with, 4 we disagree and we're okay with, except we believe 722.35 to 724.01 should stay in. 5 we agree with, 6 we agree with, 7 we agree with, 8 we agree with, 9 we disagree with. 10 we generally agree with, except we believe 751.19 to 751.22 should stay in. And we can talk about that. 11 we disagree with. So that's where we're at. So we do have a fair amount of agreement.
Okay. All right. I have an unrelated matter to take up in a few minutes, and I'll check on you all probably around 3 o'clock. Okay.
Yes, Your
All
Honor.
right. So I'll continue to work. All right.
This is them reporting back what they agreed on. And it's a new break. So this they wasn't very interesting. But I don't want to rob you of any content.
Judge, I've conferred with the state. We've gotten through, and this is just for the January 28th. Out of the 17, we are on number 16. We're in concurrence with 12, 13, part of 14, and 15, and we're working through 16 and 17. So there continues to be a certain amount of agreement. They have responded to our suggested redactions, and they agree with some of them, and then there's some disagreement. So I think we're close to having a list of where we disagree. For that one statement.
We concur with Mr. Shaw.
Okay, all right, well, I would just advise you all, unless there's disagreements to the contrary, to continue working on those other, I think, 16 and 15, 16, 17?
16 and 17.
All right.
I recognize that voice.
Eerily similar, eerily. Okay. And let's, let me touch base with you at 5 o'clock.
Okay.
I've got to decide a couple of things. One, I mean, we're off tomorrow. All right. But Thursday, if you're not done with these particular edits, whether or not we need to bring in our jurors for Thursday. Because you still have the edits for the 21st and you have edits for the 10th of June. And so we may end up having to work the next several days to get those done.
Understood.
Maybe the weekend.
As I've said,
So, I mean, because we need to get it done before I can probably listen to the, before they can be, because I need to rule upon them, and then, you know, it makes no sense to bring our jurors back in until such time as that occurs. Because you're looking at about 16 hours worth of stuff to include, and we hadn't even talked about this 2.5 hours of jail calls.
Your Honor, if to assist with the jail calls, we do have a jump drive if the court wants to listen to the jail calls, so that all we have to do is.
Not only do the prosecution want to play 15 hours of interviews, they want to play at least 3 hours of jail calls to impeach Woody.
Argument, to make that portion a little quicker, we do have a copy of the jail calls. The court, I think, has a copy with the jump drive that we served on but the jump drive that.
They have different formats because the prosecution refuses to use a normal format, which it makes it an issue for the defense. I believe it's intentional. They send over the material, the defense can't open it, the defense gets back to the prosecution, who then answers the next day with the correct format. It's intentional.
With the Dropbox that we provided to defense counsel, it has the jail calls, but we also have just a quicker medium if the court wants to be able to listen to those, so we can just have argument at the.
Let's get through
right time.
the first 3 interviews to begin with. The 28th of January, the 21st of February, and the 10th of June. Before I worry about the jail calls.
Okay.
So state, what we're going to try to do is finish this, and then we'll try to get you a list of proposed redactions for the 21st.
That works.
Because Thursday, what I could, depending upon where you all are at 5 o'clock, what I could do is just, I could maybe take some argument on Thursday. Since if those edits are, I mean, if they're, you can tell me or flag which parts you disagree, and we can have argument. I can listen to them and we can have argument on those. Does that work for everybody?
That works for the state.
Yes.
Okay, all right. So let me check back with you all at 5 and we'll see where we are, okay?
Thank you.
Okay, all right.
And let's see here. They're out again for a while, and then they come back at the end of the day. Have you hit the like button yet? If you haven't, now it's the
Participants, sir?
time.
Okay, all right. All right, folks. So where are we at this point in time? Time being almost 5:10 in the afternoon.
So I believe Mr. Shard he just gave us the last redaction that they do not agree with. So we need to review that very quickly.
Which one is that one?
This is going to be for the state, number 16 on the states. They agree with portions of it, but other portions they think should be played.
Okay,
And so we just need to listen to it to determine if we're going to agree or not.
all right.
And we were getting ready to discuss the state. We were getting ready to talk about the redactions that have already been brought forth.
Right, and in 17, we agreed with.
17, you agree, so there's not a problem with it. Okay.
Correct.
So let me just kind of go back through it again. We have some disagreements on 4, 9, 10, 11, 14, 15, and 16.
4, 9, 10, I think we're good now.
You're in agreement? Okay.
4, 9. Could you repeat what
Was
you said?
11 one of those ones you as well?
Yes.
Yes.
Okay. Part of 14?
Yes.
What about 15?
I think 15 we agree upon.
Okay.
And then 16 is the newest one that we have to look at.
So you still haven't reached some consensus on 16.
Not church around.
Okay. All right.
And then we were actually kind of just discussing what their thoughts on our redactions are.
For the January 28th?
Yes.
Okay. All right.
Which one?
Okay. Councilors, I'm inclined to go ahead and just tell our jurors to be at ease tomorrow, because you'll need to continue to work on these tapes.
You mean Thursday, Your Honor?
Thursday, I should say. All right.
Yes, Your Honor.
And I'm also inclined to work Friday morning should the need arise and then we'll see where that leads us. All right.
Yes, Your Honor.
All right. Are we in a position, or at least for the court to hear some argument, or for me to hear your disagreements on 4, 9, 11, 14, and 16 tomorrow? Not tomorrow. Can't want to say tomorrow, Thursday.
Yes, we'll be ready. And hopefully over the course of the evening, we'll get the February 21st ones, and then we'll be able to resolve those as well, and hopefully hear on Thursday, the February 21st, if there are any concern, if there are any redactions we can't agree upon.
All right. Mr. Sharp?
I'm going to do my best to make sure that happens regarding the February 21st.
What, at a minimum, will you be ready to go on the 28th?
Yes.
Contest, the ones I need to rule upon for the 28th of January.
I'm going to be in contact with Ms. Hilton, and she now knows our disagreements with her suggested redactions. And so I think the goal of both of our goals is to just isolate where there's disagreements to present to your honor. And maybe we can do that for the 21st.
All right, well, we'll just continue to work, and I'll have my staff get in touch with our jurors and for them not to come in. Them not to come in on Thursday. Friday was already an admin day for them, but it will probably not be for you. We'll be working on these particular transcripts, or not transcripts, but these particular interviews, okay?
Yes, Your Honor.
All right. Okay, any other things I need to take up with you, anybody, before we recess for today?
I'm sorry, Your Honor, our start time on Thursday is going to be at 9.
Yeah. And that was day 94. Let's see. Day 95, where they continue this cluster F.
All right, good morning, Ms. Knight. Okay.
And we have,
All right, so where we left off on Friday, were some discussions about areas from the January 28th, 2015 interview of Mr. Copeland that you all were
now we
looking
are
at.
at
So
Monday.
what updates do you have? Good morning, Ms. Atkins. All right.
Well, the judge decided after hours.
Good morning, Your Honor. As
that
it relates to the
they
January
should not
28th
be
interviews,
back this week.
I believe that we're in a position to discuss those portions that are in dispute. We believe that it should only be
Do you want to give it to me in the areas or that are in contention? Because I think that Mr. Sharp last week told me that of the 17 areas that you had 4, 9, 11, 14, 15, and 16 in some part.
yes, Your Honor.
Is that still the areas of contention?
4, 5.
I have 4, 9. I don't think. I don't have 5 either. I've got 4 and 9, Ms. Hilton. 4, 5, 4, I'm sorry, 4, 9, 11, 14 in part, 15 and 16.
You're correct. I'm sorry. 4, 9. My numbers were off.
Is that correct, Mr. Sharp?
I don't have part 15.
Yes, I know.
Oh, you're right.
Most
15.
interesting
I've got my,
content,
I've
but
scratched it
I
out.
don't want
So
to
4,
go
9,
through this
11, part
file
of 14 and 16.
and then realize I missed something.
Yes, sir. That's what I have.
Okay.
And if I have
Yes,
to
4,
suffer,
9, 11,
you have to
14 and
No,
16,
I'm
parts of
just
16.
joking.
And then the defense had redactions as well that the state would need to address.
Okay.
Try to do with this.
So I can start with the state's version. I don't believe that the court has a copy of the redactions that the defendants had, and I don't know if they have it in an electronic form or not.
All right, well, can we address, just taking by the numbers and we'll take 4 first and then I can, then the defendants can identify which parts they believe are in contention and I just work it that way.
Yes, Your Honor. If you don't mind, I'm gonna sit at my seat and I'm gonna have to play portions of it.
All right, let me see if I can. Already named our discussion, what new states he's able to are you going to name, or have you already named the January 28, 2015 interview?
This is gonna be 378 Yankee
Now
Bravo.
we are coming up to an interesting situation. Don't know if it was day 95 or day 96, where in one of these jailhouse calls, Young Thug, his name shows up. And that will be a matter of contention.
38 Yankee Bravo.
All right.
So, Your Honor, the portion that is in dispute is from 7/22/16 to 7/24/54.
Give it to me again, 7/22/16.
Yes,
For what time?
7/24/54.
All right.
The defense would like 7/22/40 through 7/24 played
They like 7/22/40 to 7/22 what?
to 7/24 played.
Okay.
The state agrees with portions of that. We agree to play 7/22/40 through 7/23/33.
Okay.
The portion that's in contention is 7/23/33 through 7/24. And I'll play that portion.
I made a suggestion. We just play it's only 2.5 minutes long. We just play the whole thing so we get context and also my sections are a little different than yours. So I just don't want us to get confused about that whoever starts out that would ask you better.
So that was the state's intention, to play the whole portion, but I want to give the court the areas that are at issue.
Let's just play the entirety from 7/22/16 to 7/24/54.
And it's after 2 hours, so I can start cursing. George Glanville, you porkwad. You know what I mean. This is such a waste of time because none of this should be allowed, since they already
And we're going to
asked
start at just a
everything
little
that was
before
going
7/22/11.
on. They spent a week and a half.
Right.
for
I can say
all
I
of what was said
I
in
feel like,
those
why is it wrong?
reviews. Everything. And now they're just going to play it because they can, and George Glanville allows it. See.
Has concerns with this from 7/23/33 to 7/24, in which Mr. Copeland says he's hearing stories like Nut's supposed to run off with something, you know what I'm saying? And it goes on to say, yeah, Nut's supposed to ran off on somebody with some jewelry. And that's the entire section. Outside of what we agreed it should be redacted.
Okay.
I think it is on.
It's on.
Green light's on.
All right, sir.
So, Judge, appreciate the opportunity to respond. In this section, there's essentially three different portions as far as I can see. The first portion talks about, Kenneth Copeland talks about Thug's sister saying that Bloody J said that Thug is gay. Speaking for myself, and I believe I'm speaking for everyone else, but if I'm not, please speak up. I don't think that we have a problem with redacting that. That would be hearsay. From 722, about 33 or 35 maybe, to 724. That is a section that talks about what do you think happened? Or if you were to guess, what would you say happened? And Mr. Copeland gives various theories, head and doc, and then talks about a theory of that he heard from other people. I can see that he heard it from other people that ran off with, it sounds like he's talking about drugs, ran off on someone and got himself in trouble. The reason that this is important, it's not for the truth of the matter asserted, as hearsay would be. It's important because the state's theory in this case is that on January 10th, 2015, late at night, Kenneth Copeland went and picked up Demekion Garlington at the McDonald's on Cleveland Avenue. And Demekion Garlington told Kenneth Copeland that it was Shannon Stillwell and Demonte Kendrick and Justin Cobb and Demise McMullen in this car that did the shooting. So according to the state's theory, on January 10th, 2015, Mr. Copeland has that knowledge on that date. This interview is 18 days later. Presumably, if that were true, that Kenneth Copeland was given that information on January 10th, when Investigator Dennis says, Mr. Copeland, what do you think happened? Presumably, if he was given that information on January 10th, that is when he would say, this is what I think happened. I think Shannon Stillwell and Diamante Kendrick and Justin Cobb and Demise McMullen were in a car and they shot Donovan Thomas, if the state's theory is correct. But Kenneth Copeland did not answer it that way. Instead, he said, well, Doc and Head, they may have done it, but I really don't think they did it. And I think it had something to do with Donovan Thomas running off with some money on, a bad drug deal. And that's what I've been hearing. So it's not for the truth of the matter asserted. It's impeachment of Kenneth Copeland to show that his story that he was told on January 10th is not accurate.
Mr. Copeland's version he gave on January 10th.
Well, he didn't give it on January 10th. He gave, so let me rephrase. Mr. Copeland on June 10th, 2015, after this interview, later says, Demekion Garlington told me this on January 10th. So on June 10th, he says, I was given this information on January 10th. But on January 18th, when he's asked about it, he doesn't say it.
Okay, I see. That's what you're saying.
So that's the purpose of it. It's just like any other impeachment. You had an opportunity to say something and you didn't say it, and now you're saying it on a later date. And now the difference between January 28th and June 10th is on June 10th, all of a sudden Kenneth Copeland is facing 5 or so felony charges and federal charges, and then all of a sudden he has this information. But on January 28th, when he wasn't facing those charges, he didn't give that information. He said Doc and Head, and I don't know if they did it. And then I think it has something to do with Donovan Thomas running off on a drug deal. So that's why it's important. It's impeachment evidence.
Okay.
And the fact that he did not say it at that time is important. And we need to get out what he said to show that he was responsive and not saying our clients.
Tiny bit of whiskey.
All right.
And just to, from 7:24, approximately 7 minutes and 24 seconds. The third part of that,
you said 7:24 to what, sir?
To the end, 7:24:00 to 7:24:54.
Yes, sir.
He's talking about an unrelated thing about Rich Homie Kwan supposedly putting $25,000 on the head of a gentleman named Tay. We agree that that's unrelated, and that I don't know if that's hearsay or not. It's a little unclear, but it's unrelated. So we don't have a problem with 7:24:00 to 7:24:54 coming out.
All right. So
But
do you have any further issue? Do you agree with Mr. Shard about that period? I'm just trying to.
Are we talking about the last portion?
Yes.
Yes, Your Honor. From
Okay, so you all are in
7:24.
agreement with that? The court's
Yes.
in agreement with that as well.
Yeah.
What about the statement they also, Mr. Shard agrees with, says that about Thug's sister said that Blade J said Thug was gay?
Yeah, we agree with that portion as
So
well. It's a very limited
We'll
portion.
take that out as well by agreement. So let's hear argument on Mr. Shard's issue of whether or not it's impeachment, just straight out impeachment.
Yes, Your Honor.
And that would be 7:22, 33, 35 to 7:24.
Yes, Your Honor. So the state has no issue with the portion up until he talks about Doc being arrested for it. So that portion in which Mr. Copeland says, I heard that Doc and Head were arrested. We don't have an issue with that. The portion that we have an issue with, Your Honor, that we believe should not be played is the portion where it's specific.
Now, let's see if I can get this up. This is interesting. It's subscription. Let's see if I can find this. Canton Police Chief, for you who follow the Karen Reed case, which takes place in Canton, cited for hitting pedestrian with town-owned vehicle. Well, according to Trooper Proctor, now she should be a suspect in murder. Oh, just a quickie there.
Specifically, he's talking about Nut running off with some jewelry or some drugs. First of all, Copeland never says anything about drugs. We don't even know what this supposed rumor is, right? And so the state's contention is Mr. Copeland says, I heard it was about some jewelry or some drugs. He doesn't even know. And that is bad character evidence as to the victim. So the state's concern with that portion is that it's bad character evidence that's trying to come in using purported specific acts of conduct, which is improper. The only way that character evidence would come in is by reputation or opinion. This is,
Or specific acts.
no, it can't come in through specific acts, and I actually have a case to cite that.
But that's if I only consider it as character. I mean, so the defense is saying that it's impeachment. It could be used for impeachment of Mr. Copeland.
But impeachment is, he did not say in this interview that it was Shannon, it was Shannon, Demekian, et cetera. That portion will be relevant for what happens above, where he says it was Doc and Head. But here, he's saying there's a rumor out there that some other people.
There's a rumor out there. This, again, is the prosecution's case. Gossip. Gossip. It's all there is. Gossip, gossip, gossip. Hi, Eve. Appreciate this recap and live. Some of the others on YouTube are chaotic. Yeah, I know. I don't believe in drama. I mean, it's unnecessary. I honestly don't believe all the drama is genuine. And I will leave it at that. But it makes good content.
May have done it, but we heard that Nuts may have stole some jewelry. That's not specifically talking about any specific person. That's him giving a theory based on a rumor that he heard. So that's why we don't have an issue of the Doc and Head portion coming in, because that could be considered impeachment given what he says later on. We are solely concerned about the portion in which he says, I'm hearing stories like Nuts supposed to have ran off with something. He's not talking about anyone specific, and he's talking about these rumors. And again, that is bad character evidence.
If the defense on cross-examination lays the foundation for, as Mr. Shart said, he has knowledge that Mr. Copeland knew of this earlier. And then on the interview in question, he's saying something that would be different. So if he had knowledge of it and he gave it, that would be impeachment.
If he had knowledge of what?
If he had knowledge beforehand, what they're doing is, I just, from the court's recollection or this assessment of this, they're working kind of backwards. They know what he said later about what he knew earlier. So that's where the impeachment's coming in. They have a good faith basis to ask him about that. Mr. Sharp, I'm sorry to interrupt you and Mr. Steele, but is that kind of what you're trying to get at?
Absolutely.
All right.
If he had knowledge of it on January 10th, that was his time to say it. He didn't say it, so that suggests to us that he's making it up.
Wow. Judge Glanville. This is the first time in this trial since November 28. Judge checks in with the defense if his argument here against the prosecution is the one the defense is trying to make. Huh. Is he sick, Mr. Glanville? Did he have a stroke?
On June 10th.
But what is the it? Because the fact of
He's making up, what exactly is he making up that's relative to this particular section?
He's making up
This particular section of 732-33 to 724.
on June 10th, he is asserting that he has knowledge of this, and he's had knowledge since January 10th. And he's asserting that his knowledge is that the four gentlemen in the car, who the four gentlemen in the car was. And if he had knowledge on January 10th,
Why didn't he say it on the 18th?
why didn't he say it on the 18th?
Okay,
but you're right, I think let me
Or
be
the 28th?
the 28th, I should say.
and let me be clear, the section that we're talking about, the conversation about Doc and Head is in the same section. So in the same section between 723, between 723-33 and 724, he talks about Doc and Head, which we agree should come in. In that same section, he also now talks about this rumor of Donovan Thomas stealing some items. That does not directly talk about who killed him.
Prosecution, this has been your argument to get other rumors in. And now, because it doesn't fit your theory, you don't want that in. Oh, it's so stupid.
So the Doc and Head part, we agree with. That's a part of this 723-33 to 724 section. So we agree up until, from 722-40 to 723-33 is where he talks about Doc and Head. We agree that can come in.
All right.
That shows right there He said back in head on January 28th. Later on in June, he said Shannon, Demikian, and these other individuals. We are specifically talking about a 7-second area between 7:23:33 and 7:24, where he's solely talking about hearing rumors that Nutt supposedly ran off with jewelry. That does not directly talk about who killed him. That is him speculating about what theories could have came in as to why he was killed, but it does not directly talk about who killed him. So we think the portion before Doc and Head, fair game. We are only talking about where he's speculating as to whether or not.
But here's the thing, if he had knowledge of that, or what truly happened, and he's just given another version, I heard that such and such did this during this period of time, that would be impeachment.
But he doesn't even know what happened.
But it's another version he's told that the jury can decide whether or not he's telling the truth about. Ordinarily, Ms. Hilton, it would not be admissible, but given what's been proffered so far, I'm going to probably allow it. So assuming a foundation's laid as to that, but what I've heard so far would indicate that yes, it's another version of what Mr. Copeland may or may not have said. So I'll allow it over your objection. So we're going to get rid of the things the sister said about Blade J. We're also going to get rid of the 72400 to 72454.
How about that?
The unrelated 25,000. Okay. All right. Was that it, Mr. Sharp?
For that one.
For that one.
Yes. I have a disagreement.
Okay, Mr. Steele, what section are you want to invite my attention to?
And if we can have, because we weren't provided this previously, so that we can be prepared for whatever. So if you could just tell us what the section is.
I think he's going to do that right now. Okay.
So I don't agree that these statements get played at all again. So I know what you're doing is over objection because I don't believe it's a prior and consistent statement.
Okay, so you're disagreeing with Mr. Sharp about that. You're saying you don't want to play it at all.
Right.
Okay, all right.
Because
just so I'm clear about that. Okay.
And I've raised this before because the testimony was I probably did. Most of the testimony is I don't remember, but I probably did say that because I was lying to the police. So this is not a prior inconsistent statement. He's saying I probably did say this. So I don't think any of this exercise is appropriate. You've ruled that portions may come in and that's what we're doing. So without waiving anything.
Okay, sir.
And just for the record, because this is still bringing up, I just want to be clear that that's my stance as well about just playing these videos. But when I'm discussing redactions, I'm going on the assumption that you are overruling my objection.
So generally, you object on the basis of it's not impeachment. But since I'm going to rule that it may be impeachment, you'd like these sections played.
Played or not.
Okay, all right. Okay.
So the other factors I want the court to consider is over objection. You have permitted constantly the state to ask Detective Gaither, Detective Dennis, and if I'm leaving anyone out, I'm not trying to. So anybody on law enforcement, I think maybe Detective Racy as well, based upon, don't tell me what was said, but based upon your investigation, what did you learn? What did you do from what you learned? And did you corroborate that? And I don't know. I have no idea where this information came from. And I've asked the court and I said, it's a confrontation clause issue. You've denied it. I have no reports on who they spoke to gather the information that they are now putting to the jury that YSL is a criminal street gang. With Detective Gaither over objection, YSL and the people here are all involved in a criminal street gang, which is the ultimate issue.
Oh.
With that.
Detective Gaither, remember her? That is the gang expert who testified that after she left the force after 19 years, after doing more or less jack crap for most of that time. And she left the force to start as an investigator at Cobb County DA's office. She left there just 3 or 4 months later because, as she put it wasn't for her. For you who know, hi, I'm Nick. I've been doing labor law for over 30 years. What happened was that Miss Gauthier got the option of either you quit or you're fired because of incompetence. That is probably what happened. And she has testified in this court as a gang expert, a person who is too incompetent to be a DA's investigator. It's Oh yeah, she went on the stand, and according to her and the prosecution, all her reports from her entire career, and specifically the reports as a gang expert, all gone, disappeared, or never existed, or if it existed, parts of it no longer exists, except the portions that fits the prosecution's narrative, and the judge allowed it in.
Being said, this is a good example of how, and I want to play it for the jury, of how law enforcement gets their information. I want the jurors to be able to see that it's Detective, in this case, Gaither and Detective Dennis. It's the 28th day of January 2015. And they ask, what did you think? Who did you think killed Nutt? And then all this conversation flows from that question that the state is trying to keep out, including that Mr. Thomas stole from someone else. And I'm not using it for bad character. Mr. Thomas' bad character is already in evidence. The state brought up that he is the head of a criminal or leader of a criminal street gang. So under 403, which is 24-4-403, it's really specious to say, oh, well, he stole from someone, so that's his character. In addition to that, I disagree respectfully with Mr. Sharp. And I want the false allegation that was made that Rich Homie Quan put a contract to kill someone for $25,000 up front and then $50,000 thereafter, because it shows another person falsely accused by Mr. Copeland. And if you listen to the whole thing, I think it was cut off. Mr. Copeland says that he actually spoke with Rich Homie Quan to kind of be the intermediary and to diffuse that situation. So it was redacted by agreement by Mr. Sharp. This court accepted that, and I am objecting to it because I intend to cross-examine this witness. And if he doesn't remember, I'm going to play that portion. And because I'm not saying, and I'll make it clear to Mr. Copeland, I disagree that Rich Homie Quan, he's a gentleman. I disagree that he committed any type of offense, but this is the exact statement that Mr. Copeland levels against Mr. Williams, that Mr. Williams put a contract out on Mr. Copeland's life, which is untrue as well. So okay. I'm disagreeing. And those times, if you need them, that you already removed them.
I think it's no. It's subject to further argument since you made your issue. So I'm gonna hear them. I'll hear it again, and I'll make a decision.
Okay. But those are my. So
okay.
I'm not trying to use it for character. I'm not using it for of the alleged victim. I'm not using it for of the victim, the deceased. I'm not using it for any type of I didn't know, and it's totally speculative. I'm saying that's how the police did their investigation, that the court through the prosecution has already poisoned the jury with this, word on the street. We did this. We corroborate. Here's how we do it. The person self-admits, or we get information, we corroborate. I think that all should never have come into evidence. And this is a perfect example to show how baseless the prosecution case is against Mr. Williams and the other, and how the detectives have not done a proper investigation. So that's why I wanted it. What do you think happened? Here it is. And I want the whole flow. That's what I'm saying.
Okay. So let me see if I can get the sum and substance of your argument. Are you saying that particular section of 724.00 to 724.54, that shows another version of the story that Mr. Copeland may have advanced?
And that this is how law enforcement gets their information. This happens to be recorded. But they were out there saying, and I don't know who they spoke with to say, and you let it in over objection. We did investigation. Then don't tell me what the investigation was. The prosecution will come back with, just tell me based upon your investigation under CIAK versus state, you relied on, and one other case that I can't remember right now. But you relied on two cases, and I disagreed with the analysis, but that's the rule of your court. So we went forward, but I want to show the jurors now how the police did this investigation. And it's preposterous because all this is a lie. Everything Mr. Copeland said is a lie, yet they're using him as a primary witness against Mr. Williams and others.
Okay. I understand what you're saying. I believe that case does indicate that depending upon, since the investigation is an issue so I'll hear it again. Okay. All right. Can I hear 724.00 to 724.54, please?
And they are playing it. Yep.
happened or how he came to find this information. I mean, if he's given the police different versions of what may have happened.
When you say what may have happened, is what he's
Yeah, what may
talking
have
about.
happened, what he told them.
But when you say what may have happened, Your Honor, in this portion, he is not talking about the murder of Donovan Thomas. He is talking about Rich Homie Quan's father was shot at in September of 2014. In this particular portion, he is only talking about the fact that Rich Homie Quan thought.
Thank you. You are absolutely correct, Patty. It wasn't Dennis, it was Detective Hamilton. And if I remember correctly, Detective Hamilton works for the DA's office.
That an individual named Tay shot Rich Homie Quan's father. This has nothing to do with the murder of Donovan Thomas.
Okay.
So this isn't him giving a version of facts as to the murder of Donovan Thomas. This portion has nothing to do with the crime of who killed Donovan Thomas on January 10th. What he is talking about is only to Corey Lamar, which is Rich Homie Quan's father. So that this would not be relevant to the issue at hand, which is who killed Donovan Thomas.
Okay, let me also kind of just ask you to just address this as well. Mr. Steve, you have made this an issue of investigation. I mean, even though of how the police got there, you know, Mr. Steele wants to challenge that particular issue of the investigation, which arguably he's entitled to do that.
Right. So the information that they got regarding the murder of Donovan Thomas is fair game, but they're not right now. They're getting information about what could potentially be a separate crime, which is not the investigation of Corey Lamar. That's what they're talking about in this section. Now, if he wants to talk about what Kenneth Copeland told them about the murder of Donovan Thomas and their investigation as related to the murder of Donovan Thomas, then he can talk about whatever they did in these interviews regarding whether or not they followed up, whether or not they got the information, they did nothing with it. But as it relates to this portion where he is talking about Rich Homie Quan, Corey Lamar, that has nothing to do with the death of Donovan Thomas. If there's anything else in this video where they're talking about what happened before with Donovan Thomas, then that's fair game, but not this portion right here.
All right.
And we don't know if this $25,000 is true or false. We don't know. So we don't know if it's impeachment because Rich Homie Quan has not testified in this case. So we don't know if this is true or false or not, or if it's impeachment at all. And if Mr. Steele on cross-examination goes into a line of questioning, that's something he may decide to do. But here is the state's case. We're not going to inject any error in this case by playing a non-relevant portion regarding the death of Donovan Thomas, because this does not have anything to do with the death of Donovan Thomas. This section right here. Now, there's another section that he wants to talk about, but this section from 724:54 to where I stopped at 727:51 has nothing to do with Donovan Thomas's murder.
All right, Madam, I'm gonna let Mr. Steele respond. Sir.
Oh yeah, this seems to be before.
This is Mr. Copeland, who is a
infamous
huge witness, as the court knows, in this case. And he is lying, my word, to law enforcement about Rich Homie Quan conducting a murder for hire. The state wants to say, well, that's irrelevant because it's a murder for hire of a different person, Tay, T-A-Y. My point is, that is the witness. It is a false allegation against another human being to do a murder for hire. The state doesn't get to limit the cross-examination to what they want it to be. And it goes to the investigation of Detective Dennis, Detective Gaither, who the court has both found over objection to be experts. And they both talked about their investigation. And they both talked about how they went about their investigation without giving specifics or who they spoke with. I had no idea when they say, based upon our investigation, we learned the following. We learned this. I still rely on my constitutional right to have that information, but I don't have it. And this is a prime example that they get garbage. That's my position. Mr. Copeland may say it's absolutely true. The state was going to call Rich Homie Quan. His name's Mr. Lamar, L-A-M-A-R. I guess now they're not. I may call Mr. Rich Homie Quan after it comes out that, if I need to, that he put a killing on someone else. Mr. Copeland may say, yeah, I was lying to the police, which I have a good faith belief that he was lying to the police. So I need to show the jurors, and the jurors need to see, to collectively understand how the police are going about this investigation and who they're dealing with and who the witnesses are that are giving sworn testimony before the court. So I believe it all comes in.
Okay.
And Your Honor, Mr. Steele would be assuming facts, not in evidence. We don't know because there's no evidence before this jury because it's not relevant for this issue whether or not Rich Homie Quan did or did not do the $25,000 for hire. That there's no evidence before this court, before this jury to impeach as to that issue.
But I think
So-
that would have good faith basis to ask it.
But they don't, they can ask.
It would be one thing if they don't know that, but they do. They have a good faith basis to ask it. He's on cross-examination.
But he's not on cross, he's on direct examination
No,
right now.
but they're going to get him on cross.
If they get
Gotta
him
get
on
him on
cross
cross.
and they played at that portion, then that's something different. But right now, for the state to play this portion, it is improper because we have not discussed at all anything dealing with Mr. DeQuantis Lamar hiring anyone, because that is not relevant to the issue at hand, which is, did YSL kill Donovan Thomas? That is the issue at hand. What happened with Corey Lamar and DeQuantis Lamar is not before this jury. So therefore, at this juncture on direct examination, there's no evidence one way or the other regarding Corey Lamar because it's not relevant. If they ask him questions on direct and over our objection, the court lets it in, then that's a different conversation on cross-examination. But right now, there's no relevant evidence regarding what happened between DeQuantis Lamar, an individual named.
It seems like somewhere between 1757 and 2035, Atlanta cops cannot for the life of them conduct a proper police investigation. Now, I do have seen a few in this trial cops that I would say are honest, at least in their testimony. But the vast majority of the cops I've seen in this trial, I wouldn't want them guarding my tractor. My tractor, you know my tractor? My tractor that says fuck? I'm not letting any of these cops come near it because they will probably see it as a challenge.
Tay and Corey Lamar. It would be improper because there's no evidence before the jury regarding those three individuals and any type of murder for hire.
I got you. Okay. All right, give me a minute. I'm going to think about it. Okay. Does anybody else have any other objection about this, this particular segment, which is segment 4, that hasn't been heard as of yet? Mr. Apt?
Just the Harvey rule and joining Mr. Steele and Mr. Shart's
Okay.
objections.
Mr. Matthews? Mr. Garner? Ms. D. Williams? Okay, all right. Okay, I missed anybody? Okay, all right. Give me 5 minutes, and then we'll take a comfort break, and I'll come back and let you know, okay?
You're right, just very quickly, the state does not intend to play them. Now, if they choose to on cross, but these are our redactions that we have propounded. This should not come in. And so we are going to object. I mean, the state would not play this portion. If they choose to, we would object at that particular portion.
All right, I understand. Okay, we'll be in recess.
Again, having the cake and eating it as well. Oh no, we don't want stuff that speaks against our theory be played during our case in chief. Let's see what happens after the break. And here they are again.
All right, so we'll State, you can go ahead and start working on those edits, okay?
Yeah.
All right. All right, let's cover the next period of contention. That's number 9. What does number 9 go from?
And again, Your Honor, I want to make sure, because I think I want to orient that the list that we're going through now is what the state intends not to play. In section number 9, these are areas in which the defense wants to play. And
Can you tell me first what areas you're not contending to play, and then I can ask the defendants, or if you've got those, which areas the defendants want to play?
so we are not intending to play 748.10
748.10
through 749.30.
through 749.30.
Yes, that's the next
What we
section.
are talking
Okay.
about are hours and minutes.
And so
Not
we will not
minutes
play it. We
and
believe it's
seconds.
bad character of the victim. Again, I will play that portion for the court. And we will be objecting for the defense to play that portion when they get Mr. Copeland on cross-examination.
So you don't want to play it during your examination of Mr. Copeland. Is that what you're saying?
Correct.
Okay, all right. All right, let me hear it.
This could be interesting. But before that, for you who don't believe, I have a tractor that says fuck. I have a tractor that says fuck. Told you. Now, the reason I bought it, well, I did need a smaller tractor. But having that license plate certainly helped. Let's get back to the trial.
And we're starting a little before 7:48:05.
I mean, yeah.
What you know about not having anybody else knock off?
I mean, I'm pleading, but I don't know too much about it.
What about the boy in Walker?
So,
School.
I heard something, but it wasn't much. It was just like, all he did on California. Somebody had him killed. That's all I heard. All the schools did. But he robbed folks. But when he comes to the jail, like, I ain't said, but he's always, like, he's paranoid. Yeah. But I ain't know that what he was doing. Right. You know what I'm saying? But he was paranoid. He's come to the jail. He be like, so I gotta go. Yeah.
But everybody
just come out of the weed and hit jail. What the hell wrong with
think that as a saint. Like,
yeah, like, it's like people don't like me now. But I'm like, college girl. It be that trade. I'm like, it is like, who the dude on Cleveland you talking about? Some girl, like, it's damn. I think Nick got shot. He didn't die, he just got shot. Nick, I don't know his name. But he did pieces out of his hand. You know what I'm saying? But I think I went wrong when I let go. No, like, I like check.
And so the portion would end at 7:49:33, but from 7:48:10 to 7:49:33, the state does not intend to play.
All right, I'll hear argument from the defense. Anyone? Mr. Sharp?
Your Honor, we don't have any reliable transcripts from this, so I'm going off of my notes. It wasn't clear to me from what was just played, but what I believe what leads into this conversation is Investigator Dennis asking what he knows about not getting people knocked off. And that's what leads into the scooter conversation. Now, we believe that this is relevant because not for the truth of the matter asserted, but for Kenneth Copeland's state of mind. Mr. Steele, in opening, strongly suggested at least that Kenneth Copeland is the real killer. Additionally, we know that Kenneth Copeland we've received Brady information. He was lying to investigators for years about this, but he's acknowledged that he in fact stole from Mr. Donovan Thomas, known as Nut, stole a chain, a phone, and other belongings from Mr. Thomas at some point. Mr. Copeland also said,
here's the thing. The prosecutors knows this, that Copeland, if correct, definitely had a motive. And according to information in the ex parte meeting, he said to the prosecutor that he would say on the stand that he committed the crime of murdering Donovan Thomas.
in his statements that the Bloods, and with the approval of Donovan Thomas and another gentleman named Mo in prison, put Kenneth Copeland on the menu, meaning he was fair game to kill. The fact that Kenneth Copeland believes, whether it was through hearsay or otherwise, believes that Mr. Thomas has knocked off other people goes to Mr. Copeland's motive to commit this crime. self-preservation, essentially, that he's going to get knocked off. So he preemptively shoots or Mr. Thomas, I should say. So we believe that his state of mind at this time and his knowledge, or at least even if it's not firsthand knowledge, his perception, his belief that Mr. Thomas is capable of ordering people's deaths is relevant in this case.
Okay. Ms. Hilton?
Your Honor, for a couple of reasons, there's no good faith basis that Kenneth Copeland murdered Donovan Thomas. Your Honor,
Really?
a couple things that Mr. Shard said, I'll address. One, in the interviews that Mr. Copeland had with law enforcement, beginning from January 11th all the way to June 10th, one, he has consistently said that he was not near the murder scene at the time of the murder. The phone records support.
Neither was Mr. Williams, and you still are trying to pin it on him.
The fact that Mr. Copeland was not near the crime scene at the time of the murder. And when Mr. Copeland talks about the issues that he had during this time period, he has repeatedly said in all of the interviews that he has never had an issue with Nut. Matter of fact, he has repeatedly said that him and Nut were cool, were friends. Well, not friends, but at least cool, cordial to each other. So this idea of having...
But did you investigate this? Everybody is saying they were cool with Nut, with Donovan Thomas. What makes Copeland so special that you choose to believe him? Oh yeah, he's snitching. That's it. Hi, Fiery Red. Hello. Good to see you. Good to see you.
Having to go into Mr. Copeland's state of mind is not even a proper purpose to bring in the rumors that he has heard about Mr. Thomas doing anything. They're trying to get in backhandedly a some other dude did it defense, in which, one, they would have to affirmatively state that one of these defendants did it. Right now, they're saying they weren't there, they were nowhere near the crime scene, that this did not occur. So there's no evidence that Copeland did it, and he cannot argue that Copeland is a person who did it when there is no evidence to support.
You never investigated it. Of course, there's no evidence. You can't hinder the defense from bringing forward a theory based on Donovan Thomas' own lies and what he did eventually say. Because we didn't investigate it, and therefore there is no evidence, and therefore the defense can't use that defense. It's so stupid. Hi, Fire Red. You have an appointment with your disability advocate shortly. I hope everything goes as good as possible. Well, Sylvia Edwards, she's speaking herself into this whole testimony is rumors. Yeah, the entirety of Kenneth Copeland's, also known as Woody's, testimony, it's all rumors. It's just that he sometimes phrases it as fact. It's gossip. I hear more credible stuff from bingo ladies.
Support that assertion. There's none.
Well, doesn't Detective Dennis in this particular interview say that, hey, that you might have done it?
No, he does not say that. What you heard him say in that last person is that's what the rumor says. That is what the rumor is, that you did it. And that is what's happening. There was a rumor out there that Kenneth Copeland did it, hence why Kenneth Copeland's home was getting shot up multiple times. But there was no evidence because
there was no evidence because nobody cared to investigate.
What Kenneth Copeland says to all the police, every interview is, this is where my day was. I woke up at my girlfriend's house. From my girlfriend's house, I went to Mechanicsville. Then I got the phone call from Demikion. I went down to McDonald's. And when I went to McDonald's, I picked up Little D. Now things are changed because back in 2015, he says that both Little D got into his car and Nard got into his car. Now it's Little D and Shannon. But the fact of the matter, he says at the time of the murder, he was at his girlfriend's house. And that is corroborated by evidence that will come in from his phone records that at 7:25, I believe, he is nowhere near the murder scene.
Because you are always where your phone is. No criminal in the history of criminals have ever had a burner phone. They have never ever left their main phone at home while going out and do crimes. Not in the history of crime in the world have that happened. I'm being sarcastic.
The phone records further indicate that he is where he says he is at the relevant times. The phone records show him going from his girlfriend's house to Mechanicsville, from Mechanicsville to Cleveland Avenue. That is what his phone records show. So there is no evidence to support this now assertion that defense counsel is making up that Kenneth Copeland is the person who murdered Donovan Thomas. And they have no evidence that Copeland did that. So legally, they cannot argue or even suggest this to the jury. This will be pure bare.
They don't have evidence because your police officers refuse to investigate. That's a part of the defense. Because the cops never investigated, and there are indications. There is a clear line to that defense.
Speculation based on no evidence at all. So this idea that we're going to throw out this rumor as evidence cannot occur. Secondly,
why not?
That now we're going to go to his state of mind to show that Kenneth Copeland would have a reason to kill Mr. Thomas isn't true because there's no evidence to support that. And then I believe Mr. Shaw brought up this meeting that occurred maybe the night before Mr. Thomas died.
There is no evidence because Officer Gautier's notes, records, everything is gone except conveniently the few things that supports the state's case.
And what Mr. Copeland says is, I don't think Nutt was at that meeting. He never puts Nutt at that meeting. He says Mo was on the phone calling from jail. Bloody Jay was at the meeting. He said someone said Nutt might be, but I don't think Nutt was there. So at no point in time was Nutt a part of the meeting that they're trying to bring forth to the court that some way, somehow, Nutt had a hit out on him, because that isn't true.
All right.
I disagree with some facts. So I respectfully disagree with some facts that Ms. Hilton just put out there. First of all,
I wasn't finished.
Okay.
Thank you.
Okay. Well, all right.
I'll let it finish.
Thank
Yes,
you.
sir. Thank you. All right.
So additionally, Your Honor, they're trying to bring in, again, bad character of the victim, and it's only admissible if the defendants are saying that they did it and that they were justified in doing it because they know about some specific acts that they did.
No. This is impeachment of the witness. This is not bad character about the victim. This is to show that the victim is a liar, is a lying liar who lies. Now, in the beginning of this stream, I said Copeland isn't afraid of anything or anyone. And I stand by that. He's not. And that makes him dangerous in two ways. One, he's not scared. He can do anything he wants. Two, he's not scared. He can lie about anything he wants.
That the victim did. Here, they're saying that they didn't do it. They don't know who did it. They weren't even around when it happened. So they can't bring in any bad character of the victim when they're claiming, they're not even claiming that they committed the crime. So it would be improper to bring in any bad character of the victim. And that's 24-405, and I have a case, if you can pass me that case. Which would be Muhammad v. State, MOHAMUD v. State 297, Georgia 532, which is a 2015 case, which was decided after, once our new evidence rules came in regarding bad character evidence of the victim. I'm sorry?
Mohammed, do you want the citation repeated?
I need.
Mohammed versus the state 297 Georgia 532, 2015. All right, what's it supposedly indicate?
So if we look at section,
Yeah, I am also happy she spoke about that case.
so in section or division 3 of the opinion,
I'm gonna get to it.
sure, 297, Georgia 532.
All right, I'm in section 2 and 3. What
Yeah, so
section? You said section 3, right?
section 3, Your Honor.
Sorry.
Oh, this is good. This is good. Yeah, you all know. Some of you know what's coming. Some of you have. Why are we so excited? Oh, you will find out soon.
All right, okay. I'm with you. I see where it says where the
Sound a bit.
Muhammad talks about 24-4-405A.
Yes, Your Honor. And so again, what they're trying to do is improper. We rest on what we just argued to the court.
Okay, all right. And now, if you're done, I'll hear from Mr. Shaw.
I am finished now.
Okay, all right, madam.
And I'll reserve time for any rebuttal, Your Honor.
All right, yes, sir.
Okay, first of all, just to deal with the Muhammad case, and that's essentially Muhammad, we used to call it Chandler evidence. It deals with, it deals with, in the self-defense case, the Muhammad essentially says that the defendant in a self-defense case has to be aware of the prior, have personal knowledge or be aware of the past violent acts of the victim for it to be admissible in a self-defense case. That has nothing to do with what we're talking about here today. Has absolutely nothing. They want to cite to a case that deals with a completely different area of the law and then base it on, well, because it doesn't fit this, therefore it's not admissible. We're not talking about self-defense. We're not talking about our client's knowledge of Kenneth or of Donovan Thomas's prior violent acts. We're talking about Kenneth Copeland and his knowledge of Donovan Thomas's violent propensities.
Let me just talk with you about Muhammad. Muhammad indicates that under 405 that generally it makes a distinction from the evidence rule set forth in Chandler before the new evidence code took effect. So they're saying now in all proceedings which evidence of character or trait of a person is admissible, proof shall be made by testimony as reputation or by testimony in the form of opinion. So therefore, as a general rule, character evidence of a victim is limited to reputation or opinion, not specific bad acts.
Well, in that particular context, Your Honor. And if I was representing Kenneth Copeland, who was once charged with this, by the way, with the murder of Donovan Thomas, he was charged by Detective Thorpe and thrown in jail. So to suggest that we have no evidence, well, the state actually did charge him with the murder. So, but if I was representing Kenneth Copeland,
at one point, Woody was charged with this. Charges was dropped. So it's so stupid.
I would be arguing that Kenneth Copeland had personal, and it was a self-defense case. Muhammad would be on point, and we would be duking it out. But I don't represent Kenneth Copeland. I'm not saying it's a self-defense case. Muhammad has nothing to do with this. This has to do with the state of mind of Kenneth Copeland as another person who was charged with this murder, and his potential knowledge of what he was into by running afoul of Donovan Thomas. Now, a couple things that I disagree with.
And this should be allowed for the jury to know that somebody else was charged. Even if the charge was dropped, they have a right to know.
What the state said. State said that Kenneth Copeland said Donovan Thomas was not at the meeting. My recollection of the statement, I just went over it. Initially, he said he wasn't, that Donovan Thomas wasn't present at the meeting. And then he said, no, I think Donovan Thomas was there. He does say Bloody Jay was there. He says Mo was on the phone. But he also puts Donovan Thomas there. Secondly, the idea that the phone records show he was in a different part of Atlanta. Kenneth Copeland's statement puts him at the Green Store, which is maybe 300 yards, 250 yards from the scene of this shooting. Okay. So we're acting like, oh, well, and we know how cell phone records or cell tower data works, and it's not the exact time. And obviously it goes by towers. So my understanding of the cell phone records, and I'm sure we're going to hear expert testimony on it, is it's not nearly clear cut like the state says it is. But Mr. Copeland's own statement puts him at the Green Store. So, which is right there. So, and Your Honor, the other thing is the state can say, oh, well, there's no evidence because Kenneth Copeland repeatedly said he had no issue with Donovan Thomas. Well, on my client's behalf, I guess we had no issue with Donovan Thomas. So I guess the case is just dismissed based on what we say. I mean, that's not really how it works.
Hello, folks from Valhalla Awaits. Welcome to another crap show. Hey, Val. Good to see you. My Valhalla Awaits is my secret son, and you should all subscribe to his channel. Flux! Yay! Hello, Flux. We are currently listening to a hearing about a type of evidence where the state claims to the court that a person, Kenneth Copeland, there's no evidence that he committed the murder of Donovan Thomas. Kenneth Copeland is the main witness in the prosecution's case in the RICO trial against 6 defendants. And now we found out that at one point in time, Kenneth Copeland was actually charged with the murder of Donovan Thomas. And the prosecution claims there's no evidence. The prosecution lied to the court by claiming there was no and it was none, is none, and never will be any evidence against Kenneth Copeland for the murder of Donovan Thomas. And then the defense says, you know what? The state charged Donovan Thomas for this murder at one point in time. And this is Attorney Shard. He is the attorney for Shannon Stillwell. Shannon Stillwell is accused by the prosecution to commit this murder. So go back maybe 15, 20 minutes, play it in 1.25, and you will catch up, because this is stupid from the prosecution.
He said he had no issue with Donovan Thomas. And since those statements were made, he's actually clarified and said, no, I was actually lying when I said all that. And in fact, I stole from Donovan Thomas. And the state handed that over to their credit as Brady material. So, you know, just because an individual says I'm not a suspect doesn't mean they're not a suspect.
Can I ask you a question? Just to address the elephant in the room. Did you say earlier that you did represent Mr. Copeland earlier in these proceedings?
No. I was saying hypothetically.
Okay. All right. Okay.
I was saying hypothetically.
I just want to make sure. Okay.
If I was representing Kenneth Copeland on.
Okay. All right. Because you did say that he was charged with a murder, and
he was charged.
Okay. All right. Enough said. Done.
Yeah.
All right. Okay.
No elephant in the room thing.
Okay. All right. Okay. No, I want to make sure. All right.
Yes, sir.
Okay. Anything else?
Yes, Your Honor.
Mr. Short, anything else? I'm sorry.
No, Your Honor.
In terms of this. Okay. All right, sir. All right, madam.
So first thing regarding Mr. Copeland being charged, were the arrest warrants taken out? Yes. However, when the case came to the district attorney's office and we investigated the case, we did not indict him given the evidence that was presented before us. So Mr. Copeland has never been indicted for the murder of Donovan Thomas.
Yeah, but you still claim there's no evidence. The investigators at the time, albeit absolute rubbish investigators, still charged him and handed it over to the prosecution's team. That should be presented to the jury. And you don't want it presented to the jury because it speaks against your case.
Second, Your Honor, looking at 244405A, what the defense is asking you to do meets no exception. And they have not brought to you any case law that says the state of mind of another individual that they are claiming killed someone with no evidence can come in. But they have not presented any case law, because this is what they're asking you to do. They're asking you to bring in evidence of the state of mind of someone who they think killed Donovan Thomas with no evidence that that person killed Donovan Thomas. If they have some case law to say that the law allows that, we would like to see it. But according to 244-405,
now, in all fairness, this should be in the defense case in chief. Then they can bring this up. This is the state's case in chief. We are almost 8 months in. It's still the prosecution's case. They are arguing about if the jury should see 15 hours of video and 3 to 5 hours of jailhouse calls, and what should be redacted and what should not be redacted. And it's insanely stupid.
what they're asking you to do meets none of the exceptions in how character evidence of a victim can come in.
Okay. All right. Anyone else have any argument on this particular section? Mr. Steele, anybody else? All right, sir. Go ahead.
Listen to this.
I was the lawyer in Mr. Muhammad versus State of Georgia, and I agree.
The prosecution brought up a case, Muhammad versus the state of Georgia. It was a self-defense case in which the statute is character testimony is not allowed. Attorney Steele was representing Muhammad in that case. He, if anyone, knows what went on in that case. The prosecution brought up a case in which defense attorney was the defense attorney. And look at, I will go back a bit. Look at Miss Love. This is Miss Love, main prosecutor. Look at her face when she finds out.
I was the lawyer in Mr. Muhammad versus State of Georgia, and I agree with Mr. Sharp. It's not on point here.
She looks over at Hilton, shaking her head, going, "What the fuck?" And this happened a few days ago. This is a recap or catch-up stream. At the time, I was told, well, it was a Twitter comment about how stupid I am and all of that. Yeah. But this is so beautiful.
In this issue, the prosecution keeps saying that there's no evidence that Mr. Copeland killed Mr. Thomas, yet on 4 occasions on the short direct that we had already, the state asked Mr. Copeland whether he killed Mr. Thomas. The jurors don't have to accept his answer. The state has put that ball well in motion. In addition to that, to say that phone records clear Mr. Copeland, phone records are totally going to be in debate and it's up to the jury. And to say that the state cleared Mr. Copeland and therefore he's not, he's truly not involved in any wrongdoing is preposterous. That's again up to the jury. Mr. Thomas's character is already put in issue. The state did that. They called him the leader of a gang through Detective Gaither and through Detective Dennis. So to now try to close that door when they opened it is inappropriate. And to say that there's no good faith belief, the state sent an email the court was included on where they say that Mr. Copeland said that there's a video with him included I believe him included. If I'm wrong, I have to refresh my memory. Saying that he killed Mr. Thomas. And the state's asking for the defense to give them the video, which I'm not going to give to them until I use it. If I choose to use it in my case on cross. So, I don't understand there's no good faith. So with all that being said, you then go into what is the real relevance of this? And it's the same thing that the court that I argued earlier, and the court seemingly agreed. It's how the police did their investigation. Detective Dennis said, and I quote, to Mr. Copeland, we just heard, you are the prime suspect, but pull yourself out of the equation. That's how we got here. That's how this prime witness got to be the prime witness. He is making up statements against Mr. Williams and others. And I believe that everything that he said based upon his lies, I'm not saying Mr. Thomas had anyone killed or put a hit on anyone. It's the same thing as Rich Homie Kwan. It's another false allegation by Mr. Copeland. The jurors get to see, because I'm asserting that Mr. Copeland made false allegations against Mr. Williams and others. So that's why I believe that's relevant. And the state shouldn't be able to just say to the court, well, we are God and we decided Mr. Copeland had nothing to do with it. Therefore, these statements don't come in. That is for the jury to determine.
All right.
Your Honor, again, if you listen to what Mr. Copeland says, he doesn't say Mr. Thomas had someone killed. He says, this is what I heard. This is the rumor that is out here. I don't know about that, but this is what I'm hearing. So again, Mr. Copeland has never said that Mr. Thomas did anything. This is a rumor, and yet we still don't have a case law that allows what they're trying to have the court do. There is no exception to bring in what they're trying to do, which is a specific act to show the character of Mr. Thomas.
Here's the thing, Ms. Hilton. You are trying to get things excluded. Then you provide the case law to get it excluded. If that fails, it fails.
Mr. Thomas, if they're trying to bring a character, it has to come through reputation or opinion. That's first and foremost.
I don't think it's character. I think what they're trying to do is just impeach him. And they're trying to impeach him on the issue of whether or not he has told another false.
I'm amazed that the judge actually seems at this point in time go on the defense route.
Or discrepancy. And they're also trying to bring in fact, from the interview of the police and how they asked him about this particular person.
So you're right, this will be a collateral issue because again, whatever happened with this rumor of a killing of someone else is collateral to whether or not Kenneth Copeland or anyone else killed Donovan Thomas. What we're here for is the question of fact is, did the individuals charged have something to do with the murder of Donovan Thomas? What they are asking for you to bring in is Mr. Copeland talking to police about a rumor he heard in the street. Again, if they're trying to impeach him on a collateral issue, that's a collateral matter, and it's not allowed. And there is no evidence one way or the other, again, before this jury to even impeach him on that particular portion.
There is no evidence because you allowed Miss Gautier on the stand, even though you know that her reports and her notes at the 6 or 7 years in the gang unit, all of that is gone. So you're claiming there is no evidence when you know that any evidence which are in the reports or in the notes is either missing or destroyed. That should not work in your favor.
Of his interview.
Play it again, please, ma'am.
Sure.
Why don't you play 748, 10 or thereabouts to 749, 33.
Okay.
So you might sound angrier in higher speed.
I'm going to start a little bit earlier at 7:48:06.
All right.
Hey, which note I'm not having anybody else not know?
I mean, y'all clean, but I don't know too much about it.
What about the boy in Auburn?
So, school. when he's come to the jail, like he paranoid. Yeah, but I ain't know.
What I said about an hour ago has happened. Jack Gotti, or Mr. Kendrick, through counsel, Mr. Weinstein, has filed the writ of mandamus with Fulton County Superior Court. So, let's read that in the middle of this. In the Superior Court, Fulton County, Diamante Kendrick versus Chief Judge Earl Glanville. Comes now. Diamante Kendrick, by and through his undersigned counsels, and brings this emergency petition for writ of mandamus showing as follows. Even if a judge did not intend to favor one party over another, engaging in ex parte communications is inappropriate and unjudicial. Engaging in or allowing ex parte communications presents to the public an image of a judge who covertly interacts with the party in order to unfairly advance that party's interests and jeopardizes the appearance of the independence, integrity, and impartiality of the judiciary. Wherefore, Mr. Kendrick, hold on while I do this. Mr. Kendrick respectfully submits that the present motion meets all requirements of USCR 251, 252, and 253, and this motion should be assigned to another judge for consideration. In the alternative, should this court deny the requested relief in this motion to recuse, Mr. Kendrick requests that the court makes specific factual findings and submits that Chief Judge Glanville should voluntarily recuse himself. Should the court take neither of the above actions, Mr. Kendrick moves this court for a mistrial due to the ongoing bias of the court as evidenced in the Weinstein affidavit, and on the basis that Mr. Kendrick is not receiving a fair trial, as his constitutional right of due process, and under the Sixth Amendment. Should all of the above requested relief be denied, Mr. Kendrick requests a certificate of immediate review. Let's see where it is. Yeah, they are actually, hold on. In this, they are actually quoting from the Judge Christina Peterson, where she was removed from office, from the bench, due to her actions. This emergency petition is brought under the guidance from the Supreme Court of Georgia, following redaction of a similar petition by that court. As explained by the court, in anticipation of the present petition, Chief Judge Glanville would be disqualified from presiding over the matter. A different judge would consider Kendrick's petition, and either party may appeal the final decision. Now, I will find that. I will look for the entirety of that writ of mandamus. When I find it, I will make a video on it that will be up later today or tomorrow. But let's continue with this Foster clock.
You know what he was doing? You know what I'm saying? But he was paranoid. He come to jail. He's like, so I gotta go. Yeah.
But everybody
they come out of the weed and hit jail. What the hell wrong with you? Yeah.
Everybody paint them as a saint now.
Huh?
Everybody painting that as a saint. Like,
yeah, like it's like you don't let me know. But I'm like, college girl. They be that trade. I'm like, it is like, who do on Cleveland? You talking about? Some girl, like, it's damn. I think Nick got shot. He didn't die. He just got shot. Nick, I don't know his name. But I did the pieces at the end. You know what I'm saying? But I think I went.
So, Your Honor, like he says here, it's just pieces I be hearing. He never said that Nut did anything. And when it came to talking about the individual by the name of Scooter, he said all that he did talking about Scooter came up on him, and we heard that someone had him killed. He's not talking about Mr. Thomas. He's not talking about him at all. What he's saying, whatever Scooter has done in his past caught up to him and got him killed. And then when he further talks about, they ask him again, what do you know about Cleveland? He says, I don't know. These are just the pieces I be hearing. So again, he's relaying to them rumors that he has heard in the street based upon the question that they asked him. And looking at Carlson's on impeachment by contradiction, where it says a witness may be impeached by contradiction in several ways. If you call another witness or introduce other extrinsic contradicting evidence, generally speaking, the admission of extrinsic evidence for contradiction impeachment is restricted to non-collateral matters.
Wouldn't it be collateral whether or not he killed Mr. Thomas?
No, Your Honor.
But you all asked about that on direct. You all asked about that on direct, okay? That's a material matter. That's not a collateral matter.
But listen, Your Honor, what they asked him is, do you know about not knocking anyone else off? That has nothing to do with whether Kenneth Copeland killed Donovan Thomas. They're asking him, do you know about any other people he done killed that he might have killed? And he's saying, I don't know much about that. So he says, your boy in Cleveland, he said, I don't know too much about that. And then they ask him, what about the boy in Auburn? And he says, Scooter. And then he says, all he did, meaning Scooter, came up on him and someone had him killed. He's not talking about Mr. Thomas. He doesn't know who had him killed. Then further, when they go back to Cleveland Avenue and they're asking again about the Cleveland Avenue thing, he says, I'm just hearing pieces of it. I don't know. So at no point does Mr. Copeland says, I know Donovan Thomas did this or this. He's saying, these are the rumors that I hear. So again, they're not trying to bring this in for Mr. Copeland's state of mind. They want to bring it in to show bad character. And that is collateral to, did these individuals kill Donovan Thomas, and did Kenneth Copeland say something contradictory to what these individuals killing Donovan Thomas?
Okay. All right, man. Okay.
Your Honor, if we wanted to bring it for bad character, there's a lot more low-hanging fruit that we'd be aiming at. And furthermore, the state, regarding character, the state has asked people about him buying haircuts and what kind of guy he is. Mr. Thomas, about buying haircuts and what kind of guy he is. And, he was a great guy. You know, he'd show up and we'd also start smoking marijuana and everyone would be happy. And I don't know if that impressed the jury, but the intent was, he's a great guy. So character has been placed at issue, but we're not going after character. Whether Mr. Copeland killed Donovan Thomas is clearly material. Mr. Copeland's motive to kill Donovan Thomas is clearly material. We have to remember, Mr. Copeland has stolen from Donovan Thomas. Mr. Copeland has been put on the menu, quote unquote, at a meeting a couple of days before where Mr. Donovan Thomas and his associates were present. So now to say that Mr. Copeland's belief and or knowledge, whether it's through hearsay, through rumors or whatever, his belief that Mr. Thomas follows through, of course that's relevant. Of course that's relevant.
Again, he's saying he does not know if he did it. I think we'd be in the same predicament even if he said, I know this happened, but he says, I don't know what happened. I have no idea. And yet they want to bring in the state.
Yeah, so now the jury is supposed to believe Woody after he lies. Yeah, this is the problem with the prosecution's case. It's all rumors and gossips in one way or another. And they open the door to so much crap. And for the most part, Judge Granville shuts the door for them. And they are not used to opening the door and then the judge not shutting it down immediately.
Of mind of Mr.
Okay, let's not talk about state of mind. I think it comes in just for impeachment, okay? State of mind is, I haven't heard any case law in that respect, but impeachment?
But impeachment as to what, Your Honor? Because they're saying it's impeachment to what? Because this is not contradictory to him saying.
It's contradictory to him saying he didn't do it. And you, prosecution, are impeaching Mr. Copeland now for lying on the stand, claiming, well, he's not lying on the stand under oath, but back then, in the heat of the moment, he was telling the truth.
That these individuals killed Mr. Thomas.
As Mr. Steele brought up earlier, you brought up, at least as he indicates, a few times that did our current witness kill Nut? Okay. Whether or not that's true or not, you know, if there's a foundation for that to be asked, they can ask it.
Right, but what they're trying to get into is whether or not Mr. Thomas killed someone. That's not impeachment to that question. What Mr. Thomas may or may not have done does not directly impeach the question of Mr. Copeland did not kill Donovan Thomas. So that's what I'm trying to ask. What is the impeachment?
I got you. Mr. Short, do you have any case law, since you're saying in state of mind or anything like that? I understand what Mr. Steele's saying, and that may be. Does anybody have any type of transcript? I can take a look at what was said. I can parse it out.
We have a rough transcript, but it's.
I'll look at the defense. If you got a version and the state's got a version, I need to kind of see what's actually said in writing because it's hard for me to kind of listen to it.
Yeah, it's hard for the judge to hear it, and still he wants to allow it in for the jury to hear it.
Your Honor, I can resend I believe the court may have a copy of it, but I'll resend it to you.
What do you mean? In this ubiquitous Dropbox that I never accessed?
No, we
Okay.
emailed it when we emailed the redactions, but I'll re-forward it to you, Your Honor.
As long as you re-forward it to, please re-forward it to everyone. So,
Let me give
okay.
you a copy of the one of this.
Can I see it?
Yes.
Ms. Knight, do me a favor and show that to Mr. Sharp, please. And Mr. Sharp, do you have a version you'd like for me to look at?
I'm trying to find it. We have different timestamps to decide based on different videos, so I'm working on that.
Excuse me.
Yes, this is what I need.
Ms. Hill,
Yes, sir.
can you tell me what page
Sure. It's going to be
on yours?
starting at page 134, line 1. Through 137, line 7.
Now they are just comparing notes here, I believe. So let's skip ahead a bit.
Judge, what we have on our side doesn't add any more clarity, and it has, quite honestly, a bunch of my notes from what I heard on it. So if you want that, I can give it to you, but.
I don't want to look at your work product necessarily. I just want to kind of look.
It's pretty interesting that the prosecution, this is 8 months into this trial. They have had this recording for years. And there's no transcript. It's ridiculous.
I want to look at.
Both transcripts have a lot of unintelligible.
In my possession states 378 Yankee Bravo 2. Okay. Which pages am I looking at?
Yes, it'll be page 134, line 1.
Yeah, this is just the judge going through what people are supposed to read.
Before, what I'm going to do, and then I'm going to, okay, this is only if you want audio recording from 134 to 137.
Anybody else like that?
And now
We
they
don't
will
care anyway. I don't know too much about it.
timestamp.
What about the boy on offer? Scooty.
School. I heard something. It'd be like, John Perry. That's all.
And it's equally, I can't hear the crap.
All right. Much like the court's determination on 4, the state's not going to be required to play it in their case, play it in their examination. The section between 748.10 and 749.30.33, but it can be played on cross-examination.
Yep. Judge made an actual correct ruling.
We believe that it's inadmissible, but we'll exactly in the appropriate time.
Assuming that but based upon what's been proffered so far by counsels for the defense, depending upon how it's spread, if its foundation is properly laid, I'm going to say it's probably going to be able to be played for impeachment. So that's my ruling at this time. But subject to my hearing, it can be subject to other things that may develop. Okay. All right.
Now he's giving himself a backdoor to tell the defense, nah, I changed my mind.
Okay, I'll give you back this, unless I need to keep it for the time being.
For the time being.
Okay, all right, I'll keep it. Okay, all right. The next area of contention is 11. Is that correct?
Yes, sir.
Okay.
And Your Honor, 11.
First, tell me what section of this interview is number 11.
Number 11 is page 752.26 through 7. I'm sorry. The timestamp is
Timestamp. Okay.
On and on regarding this timestamp. They want in, they don't want in, blah, 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 blah. And then they play it, and then they argue. Then they play the next thing, and they argue. Then they have a break. Now, this might be interesting.
And Ms. Hilton, did you all have a chance or discuss 9:13 and 9:17?
10 to 15 minutes ago. Parts of it. I have the entire thing, and as soon as the stream is done, I will.
For the 913 to 917, we don't have any problem with it, except on my redactions, number 14 is from 916. We kind of have cross redactions going on. So I have 916.14 through 917.11 as bad character evidence against my client. So that comes up at that point. So I do object 916.14 for that next about a minute, but from the 913 to 916.14, I don't have any problem with.
Is the state going to play 9:13?
You can only hear 5% of what I'm saying because I'm not buzzed enough. So, for you who wonder, today is Friday. The spin of the Wheel of Regrets is at play. We are $35 left in Super Chats, gifted memberships, or via PayPal to the next spin of the Wheel of Regrets. If you're completely new here and wonder what's that? This is the Wheel of Regrets. Every $50 in Super Chats, gifted memberships via PayPal, I will spin the Wheel of Regrets. Had we gotten there, it would have looked like something like this. and I would have done it. This is a part of of today's entertainment. And thank you! Buzz Baker got the message. Gifted 5 memberships. Thank you so much. It was gifted to Paradox True, Buzz Baker himself, Davance Moore, Larissa Flanagan, and Erica Olson. Congratulations. You now have access to all my members-only content. And it's a lot of it. It's not much law. It's more about me, my thoughts, the farm, the renovations. So we get to know each other better. But thank you so much to Buzz Baker, for gifting 5 memberships. And that brings us to only $20 left to the next spin. But we are here for this. So let's continue to listen.
The 917 at all?
Right, that's what we want redacted. So I guess I'm confused.
Oh, you wanted that redacted?
Yes.
Okay.
Yeah, what I'm asking is, do you have anything you want? Are you in agreement with the state? Do you want to be heard about any parts of that?
I believe that our stance is it goes into more of what we're talking about Mr. Copeland just saying things and getting to the sufficiency of the investigation and him lying about other people, as Mr. Steele has articulated during some otother excerpts. But I would, on behalf of Mr. Stillwell, I'd want to cut that off at 9:16:14 to 9:17:11 because it talks about my client's character.
Okay, I think the state's in a concurrence. They're not going to play that.
I don't know if Mr. Steele is in concurrence.
But if Mr. Steele wants to play anything else, if it's in relationship to what he purports to be investigation or impeachment, then he certainly can play it. Like, so I just want to make sure that the periods that you all definitely don't want played, and so far that's that you've agreed upon. So far that's the alleged drag queen references from 10:50 to 9:10:50 to 9:11:30, and then from 9:16:14 to 9:17:11. You're not going to play anything about that, but anything else, I've heard arguments on it, and so to the extent that I believe the state says they're going to play some of the things that Mr. Steele wants as it pertains to subpart 16, he can. He and the rest of you are, unless you object to the contrary, they're going to get played. Now, if you want to anything else other than those 2 sections I specifically excluded, they're fair game for cross.
Okay, so where we're at right now is, as far as I understand, we've been just dealing with the state's proposed redactions.
Yes.
I have 19 different redactions that I have identified to protect my client's right to a fair trial, in my estimation.
Okay.
So, and that was one of them. I should say 15 different excerpts, but that was one of them.
From 9:16:14 to 9:17:11. So it's not going to play that. So that's 1 down, 14 to go. So
all right. So and the state said that they would play for the court because they have it queued up. But from 7:01:52 to 7:03:08.
Hold on, wait a second. 7:01:52
to 7:03:08. It's a discussion where Kenneth Copeland is pontificating about possible reasons for there to be a beef between Bloody J and Mr. Williams. And Mr. Copeland is saying he has 2 sources of hearsay information, one being Bloody J, one being apparently one of Mr. Williams' sisters, where Mr. Copeland is saying, what I've been told is that Bloody J called Mr. Williams gay, and Mr. Williams holds a grudge because of that, and that Mr. Brian Williams is willing to sign Bloody J, but Mr. Jeffrey Williams has to give the go-ahead for that signing to happen, and essentially that Mr. Jeffrey Williams is preventing Mr. Brian Williams from signing Bloody J. But it's all based on things he's been told by the unidentified sister of Mr. Jeffrey Williams and by Bloody J, who my understanding is not testifying. So it's not based on personal knowledge by Kenneth Copeland. So that's what's discussed in that excerpt that I believe should be excluded. I don't, and Ms. Hilton's been very responsive and helpful in this process, but I don't know necessarily what the state's stance on some of these things are.
I want to find out. Madam,
Yes, Your Honor. So the entire section that
talking
Mr.
701.52 to 703.08.
Yes, is what defense will like out. The state has no issue with 702.26 to 703.08.
Just so you know, they are not talking about minutes and seconds. They are talking about hours and minutes. The prosecution, after having Copeland on the stand for a week and a half, they want to play, with some redactions, 15 hours of police interviews and at least 3 hours, if not more, of jailhouse calls.
That is a whole nother conversation about Bloody J allegedly stating that Mr. Williams may be gay, and that was the part of their beef. We don't want that in, so we have no issue with that.
So do I need to hear from 701.52 to 702.26?
Yes.
Which is the part in contention?
Yes.
All right, can I hear that or see it?
Yes. I'm going to start it a little earlier at 701.47.
And the videos themselves aren't really interesting. We will hear it in the trial anyway, or maybe not. It is the arguments around them.
So, Your Honor, that's the portion that the state wants in. And the reason why we want this portion in, Your Honor, is if you hear what Rudy says, he talks about previously, and it was either in this interview earlier or in the January 11th interview, he talks about the fact that he had to bring Bloody J and Thug together, and that he would invite Bloody J to different events. So I think he mentioned, like, I would tell Bloody J, if Mr. Williams was performing at Blue Flame, come through the Blue Flame, come to these places so you can get back in good graces with them. And so when they ask him what happened with Bloody J, he's now explaining what the severance was between Bloody J. And Your Honor, if you can recall, we already have video evidence from 2012 in which Bloody J, Mr. Williams, all of them are outside at the park. They were all wearing red. Donovan Thomas is in that video, showing them that they were together. And at some point, there's a break between that. And so Mr. Copeland is talking about what his understanding is of that break. We stopped right before the conversation about rumors about Mr. Williams being gay, because we don't think that that's relevant. But the fact that he talks about Bloody J went with If Gang and maybe was a part of YSL at some point is important and relevant given the context of the rest of the evidence that has come in. One, that 2012 video, and two, in the context of this, I believe it is this interview. Earlier in the interview, he talks about the fact that he used to tell Bloody J to come around in order to get back into good graces. So we believe that is relevant, and it gives context to what he said earlier.
Okay.
Oh, and one other thing, if we talk about this idea, like it's based on rumors, well, everything the court is getting ready to allow the defense to do on cross-examination is based on what he heard. So that to me is not a valid argument. They're going to come back here to say, well, this beef is based upon what he heard. Well, everything that the defense has literally just asked for you to let in is based upon what he heard. Like literally what we litigated for the last 2 hours is based upon what other people told him and what he heard on the street.
All right, Ms. Sure.
So, regarding the beginning part that the state still intends.
701.52 to 702.26.
Yes, sir. My argument would be, I mean, he's saying, I guess this, I guess that. It sounds like he's speculating to me. So that would be speculation. So we feel that it should all be redacted.
What transcript reference is it?
It is page 42. And beginning at line 3 to page 43, line 2.
You said 43, line 2?
Page 42, line 3 through page 43, line 2.
Or maybe I should do a reading about the final Mandamus petition and then just cut it out from the stream and make it into a video. You tell me, chat, do you want to hear the final Mandamus petition regarding Diamante Kendrick's verified emergency petition for writ of Mandamus? Do you want to hear that instead of this? Just say 1 for yes and 2 for no. Keep going. This is interesting. Waiting a few seconds here. Dun, dun, dun. Yes, I know Hip Hop Press, but I actually have the writ of Mandamus for the Superior Court. That has been filed today. Oh, I see a couple of ones. So I guess we are reading that one. All right. Dun, dun, dun. Here it is. Now it is 85 pages. Most of that are the same as they got to the Supreme Court. But we won't get there until, let's see if I can get it. Now we can read it here. Yeah. Comes now. That's here. Now to make it good for the, I can cut it out and make it into a separate video as well. So a few seconds of silence. In the Superior Court, Fulton County, Diamante Kendrick, petitioner versus Chief Judge Earl Glanville, respondent. Diamante Kendrick's verified emergency petition for writ of Mandamus. Comes now. Diamante Kendrick, through his undersigned counsel, and brings this emergency petition for writ of Mandamus, showing as follows. Quote, this is a quote. Even if a judge did not intend to favor one party over another, engaging in ex parte communications is inappropriate and unjudicial. Engaging in or allowing ex parte communications presents to the public an image of a judge who covertly interacts with a party in order to unfairly advance that party's interest and jeopardizes the appearance of the independence, integrity, and impartiality of the judiciary. Inquiry concerning Judge Christina Peterson. This emergency petition is brought under the guidance from the Supreme Court of Georgia following rejection of a similar petition by that court. As explained by the court, in anticipation of the present petition, Chief Judge Glanville would be disqualified from presiding over the matter. A different judge would consider Kendrick's petition, and either party may appeal the final decision. This emergency petition concerns allegations of serious breaches of the Georgia Code of Judicial Conduct that violate petitioner's state and federal constitutional rights. This petition relates to conduct of Chief Judge Glanville and not to any rulings or orders of the judge. That is important because Judge Glanville is using that as a scapegoat for denying the motion by claiming, oh, you don't like my rulings, so you do this. No, it has nothing to do with your rulings. They have said so, but you keep going with that excuse because you don't want to be excused from ruling on this because you are morally and judiciary corrupt. In the case at bar, original relief in the form of motions for recusal have been filed and denied 3 times by 3 respective movements. Likewise, Chief Judge Glanville has denied the movement's respective request for a certificate of immediate review 3 times. A certificate of immediate review is the judge allowing them, the defense, to appeal that decision during trial. Judge Glanville is trying his absolute hardest to have every appeal after the trial. Chief Judge Glanville has obstructed the defense counsel's attempt to have a disinterested party review the numerous allegations contained in at least 4 affidavits, which allege judicial misconduct and unfair proceedings. These affidavits, if true, would constitute serious violations of the Code of Judicial Ethics. A secret ex parte proceeding was held on June 10th, 2024. In attendance were Chief Judge Glanville, sworn witness Kenneth Copeland, prosecutors Love and Hilton, investigators from the Fulton County DA's office, and members of the Fulton County's Sheriff's Office. As a result of the proceeding, on June 12th, 2024, petitioner requested that the presiding judge, Chief Judge Glanville, recuse himself from petitioner's trial for, among other counts. Yeah, this is the count that we are covering right now, the murder of Donovan Thomas. Despite proceeding all requirements of Uniform Superior Court Rule 25, the motion for recusal was summarily denied without following the required procedure of USCR 25.3. Chief Judge Glanville denied a request for a certificate of immediate review. A former order denying the motion was entered on June 14th, 2 days after a motion for recusal was filed. Emergency relief is requested because the witness that was coerced by Chief Judge Glanville is presently on the witness stand. Absent emergency relief in some form, Chief Judge Glanville will control the scope and substance of undersigned counsel's cross-examination of Copeland. Anticipated areas of cross-examination include Brady material that counsel believes was disclosed at the proceeding but not provided to counsel as required by law, as well as coercive joint efforts of the bench and state. Given the conduct during the ex parte proceeding, at least an appearance of impropriety, if not actual impropriety, casts a pall over any ruling that Chief Judge Glanville will may make during the counsel's cross-examination of Copeland. This question here from Samantha Yo. Why not just send off the requests instead of holding them for after the trial is over? What's his motivation? His motivation, I would assume, is that he wants to see all of these people convicted and then lean back. And even if they are, even if it's reversed on appeal, they will at least spend 5 to 10 years in prison. Some of them cannot afford the appeal. So it's a money issue as well for the defense. Most of these, I believe The only person who can afford to appeal any conviction in this RICO case is Mr. Williams, none of the others. So it is genuinely unfair. As Glanville has found petition's motion for recusal to have been filed and presented in a timely fashion, the Weinstein affidavit to be legally sufficient, and the affidavit containing facts that, if proven, would warrant recusal, petitioner requests a writ directing Chief Judge Glanville to adhere to 25.3 and thus assign the motion for recusal for hearing before an unbiased judge. Petitioner further asks this court for a writ ordering Chief Judge Glanville to produce immediately, and certainly no later than prior to the start of cross-examination of Copeland, an unredacted transcript to defendants of the secret ex parte meeting proceeding held on June 10th. Statement of facts. Procedural history. In January 2023, nearly 18 months ago, trial began in Fulton County Superior Court in State versus Diamante Kendrick et al. Now, this might seem weird to you. What do you mean, January 2023, nearly 18 months ago? A trial starts officially when jury selection begins. That is 18 months ago. Jury selection took more than 10 months, with trial before the selected jury beginning November 2023. Following the secret ex parte proceeding, June 10th, petitioner filed and presented a motion to recuse an accompanying affidavit from Douglas Weinstein to Chief Judge Glanville on June 12th. The motion to recuse was based on the impermissible secrecy of the ex parte proceeding and the violations of the Judicial Code of Conduct that occurred during that secret proceeding. The motion was summarily denied in stanter, with a formal order issued on June 14th, 2024. Following denial of Kendrick's motion to recuse, Kendrick filed an emergency petition for writ of mandamus to the Supreme Court of Georgia on June 20th. The petition was denied due to Kendrick's not seeking initial mandamus relief in Fulton County. Yeah, we went through that earlier, I believe, or did I do it in a separate video? Never mind. The court noted that initial mandamus relief in Fulton County would not be heard by Chief Judge Glanville, as he would be disqualified, so seeking relief in Fulton County would not necessarily be futile. Thus, per the court's guidance, Kendrick brings the present petition. B. The secret ex parte proceeding. A central figure, perhaps the central figure in the state's case against Kendrick and the other defendants, is Mr. Kenneth Copeland. On Friday, June 7th, Copeland was sworn in. After being given a grant of immunity and being warned by Glanville that incarceration may be the result of refusing to testify, Copeland continued to plead the fifth. Copeland was held in contempt and ordered incarcerated by Chief Judge Glanville on that date. Glanville instructed Copeland and all parties that Copeland would be returned on court on Monday, June 10th, 2024 at 8:30 a.m., where Copeland would announce whether he was prepared to testify. Unknown to any member of defense counsel, an ex parte proceeding was held in Chief Judge Glanville's chambers on June 10th. Among the attendees was Chief Judge Glanville, ADA Love, ADA Hilton, investigators of the Fulton County District Attorney's Office, deputies, sworn witness Copeland, and Copeland's attorney, Ms. Kayla Bumpus. No member of defense counsel was present at the ex parte proceeding, despite Copeland's invocation of his Fifth Amendment rights being at a critical phase of that trial. Neither Chief Judge Glanville nor any member of court staff nor the Fulton County DA's office made any member of defense counsel aware of the ex parte proceeding either before, during, or after the proceeding. One or more members of the defense counsel were later made aware of the ex parte proceeding with sworn witness Copeland. Yes, remember this, because this is really important for the success of this writ of mandamus. He was already sworn in. Specifically, Weinstein learned that Brady material was disclosed in the ex parte proceeding and withheld from all defense counsel. Upon information and belief, the following events occurred at the ex parte proceeding with sworn witness Copeland in the chambers of Chief Judge Glanville. Upon information and belief, Copeland announced that he would invoke his Fifth Amendment right and not testify. Copeland stated that he would rather sit in jail for 2 years than testify. Chief Judge Glanville informed Copeland that Glanville could keep sworn witness Copeland incarcerated until additional defendants were tried, not just the 6 defendants currently on trial. ADA Lover Hilton informed Copeland that there were over a dozen defendants left to try. Following the above coercive actions by Chief Judge Glanville, working in concert with one or more attorneys from the Fulton County DA's office, sworn witness Copeland stated at the ex parte proceeding that he would testify. Chief Judge Glanville also presented sworn witness Copeland with a printout of the perjury statute and the false statement statute of the state of Georgia during the ex parte proceeding. Sworn witness Copeland stated to ADA Hilton that if called to testify, he would simply lie on the stand. Important Brady material that has yet to be provided to Kendrick. Upon information and belief still, in response to Copeland's statement that he would lie, ADA Hilton stated that she would not prosecute sworn witness Copeland if he were to lie on the stand. That, in my opinion, should render her without a job. You can't do this. You can't do this. You cannot give immunity for perjury. You can't. Sworn witness Copeland also stated to ADA Hilton that he would testify that he killed Donovan Thomas Jr., important Brady material that has yet to be provided to Kendrick. Yeah. In response to sworn witness Copeland stating to Hilton that he would testify that he killed Donovan Thomas Jr., ADA Hilton told Copeland that she would prosecute him for perjury if he testified that he killed Thomas. Yeah, so Hilton was prepared to give him immunity, except for the things that would speak against the prosecution. I mean, this, if true, she should never practice law ever again. These troubling facts not only implicate Chief Judge Glanville in an impermissible effort to join forces with the state to coerce Copeland to testify, but also demonstrate an illicit effort to repress Brady material that should be provided to Kendrick. Attorney Kayla Bumpus, by and through a counsel, filed a motion to quash, order to show cause, a motion to recuse on Friday, June 14th, which substantially supports the Weinstein affidavit. As a participant in the ex parte proceeding, Bumpus' first-hand account of the misconduct is credible. The facts, Attorney Bumpus asserts, are as follows. On Monday, June 10th, at approximately 8:30 a.m., Mr. Copeland and his lawyer, Kayla Bumpus, was escorted to the court's chambers and conducted an ex parte proceeding regarding whether Copeland would testify. Those present for the substantive portion of the ex parte proceeding were Chief Judge Glanville, Copeland, Attorney Bumpus, lawyers Love and Hilton, members of the court security staff and deputies, 2 investigators from the Fulton County District Attorney's Office, and the court reporter. Yeah, and then they go through all of that, which we just heard. Events in court about the time of the secret ex parte proceeding. On Monday, June 10th, all defense counsel were present in the Fulton County courthouse at or around 8:30 a.m. Admitted entrance into the courtroom 1C and seated within by 9 a.m. Exhibit A. Weinstein affidavit. Defense counsel waited and waited. Between 11 a.m. and 11:30 a.m., Chief Judge Glanville took the bench and announced that Copeland was prepared to testify. Sensing something amiss, Attorney Brian Steele, on behalf of all defense counsel, specifically asked Chief Judge Glanville about the reason for delay, providing Chief Judge Glanville an opportunity to reveal that an ex parte proceeding had occurred and the content of the proceeding. Failing to provide any substantive response, Chief Judge Glanville obstructed Steele's attempts to discover a reason for the delay. That afternoon, when Steele's understanding of the morning events was presented to the court by Steele, Chief Judge Glanville shifted focus away from the extraordinary allegations to the source of Steele's knowledge of the misconduct. When Steele refused to divulge his information, citing Rule 1.6 of the Rules of Professional Conduct, Chief Judge Glanville held Steele in criminal contempt and sentenced him for 20 days of incarceration. Now, that was the short version. in that short version, we also have Judge Glanville not knowing the difference between civil contempt and criminal contempt, where he tried to coerce Mr. Steele into revealing his source. That's the civil contempt. Criminal contempt, you don't do what the judge says, you get directed to sentencing. More or less. That's the short. Yeah. That's the short version of the thing that's not in here. D. Glanville's hearing on the motion to recuse and subsequent order. On June 12th, 2024, Kendrick filed and presented to the court his motion to recuse. During the 10-minute hearing on the motion, Glanville mischaracterized the motion as a complaint regarding his previous rulings, which we know is false. That is Judge Glanville lying to the court. Chief Judge Glanville ignored the subject matter of the motion and affidavit, which was an accusation that the June 10th, 2024 secret ex parte proceeding was in violation of at least Section 2.9 of the Georgia Code of Judicial Conduct, which assures every person, including defendants such as Kendrick, a fair hearing. And 2, in violation of Rule 211A in the revised Georgia Code of Judicial Conduct that says generally that, quote, judges shall disqualify themselves in any proceeding in which their impartiality might reasonably be questioned. I've been questioning in Judge Glanville's impartiality more or less from the get-go in this trial. Judge Glanville, during the June 12th, the hearing on the motion to recuse, Chief Judge Glanville refused to conduct the timely analysis required by 25.3. Despite Weinstein bringing this to the court's attention, Glanville refused to make any findings and summarily denied the motion. Weinstein requested at the time a certificate of immediate review. That request was denied, foreclosing an opportunity to appeal Chief Judge Glanville's ruling. Judge Glanville stated that an appeals court could look at his denial at the conclusion of trial, which is Judge Glanville. It's his way of saying, I don't care. I'm going to allow this trial to continue. I'm going to see that you get convicted and then, spend a few $1 million on the appeal. On June 14th, Chief Judge Glanville issued an order of motion to Chief Judge Glanville issued an order on motion to recuse Chief Judge Glanville. The order formally denied the motion. In that order, the court did make findings, though not in the timely fashion required by 25.3. The court found all 3 prongs of 25.3 satisfied, and the analysis should have stopped there. But Glanville did not. Applying the wrong standard and reaching the wrong conclusion, Glanville found that the court finds that a cursory review of the Weinstein affidavit submitted by plaintiffs in support of the motion contains assertions of facts to support the allegations of bias and impartiality. However, while these assertions were made to support the defendant's allegation against Judge Glanville, there is a notable lack of evidence to support the assertion. This was the first of 3 motions to recuse denied by Chief Judge Glanville. Here's the thing. If the 3 prongs are considered done, he is not the person to do a finding of the validity of those allegations. That is for another judge. Argument and citations to authority. Standards for granting writ of mandamus. OCGA, this one, allows parties to seek mandamus to compel a due performance of official duties where a defect of legal justice would ensure from a failure to perform or from improper performance. And there is no other specific legal remedy for the legal rights. To compel removal of a judge, a petitioner for mandamus must show that a sufficient motion to recuse has been filed and that the motion has not been denied after assignment to a separate judge. This is what Judge Glanville desperately don't want to allow. Hi, Brandon. Where was I? Yeah. This is what Judge Glanville desperately wants to avoid. Another judge making a ruling, because that means he is no longer in control. And he might be comfortable in risking his bar license, his future as a judge. Another judge might not be that stupid. To preclude Mandamus, the alternative legal remedy must be equally convenient, complete, and beneficial to the petitioner. Glanville has failed to follow the rules on recusal and has violated multiple rules of the Georgia Code of Judicial Conduct. When a trial judge is presented with a recusal motion and an accompanying affidavit, the judge must temporarily cease to act on the merits and determine immediately whether the motion is timely, whether the affidavits are legally sufficient, and whether the affidavit sets forth facts that, if proved, would warrant the assigned judge's recusal from the case. Glanville, following filing and presentment of the motion to recuse on June 12th, to make the required determinations. Glanville summarily denied the motion, relying on a mischaracterization of the Weinstein affidavit as a complaint about the ruling made by the court, instead of recognizing it as a list of incidents of judicial misconduct by Chief Judge Glanville. Chief Judge Glanville curiously clings to Baptiste v. State as supporting his contention that the Weinstein affidavit does not merit recusal, but there is no support in Baptiste for this position. In fact, Baptiste supports petitioner's position that Glanville's bias is of such nature and intensity to prevent the defendant from obtaining a trial uninfluenced by the court's prejudgment. This is not the first time in this trial this judge has presented case law and been completely wrong about it. Glanville's order of June 14 contains a critical error of law. The law requires that when making a determination under that rule, the court must consider whether recusal would be warranted, quote, assuming any of the facts alleged in the affidavit to be true. A judge, quote, is not allowed to pass on the truth of the allegations in the affidavit, end quote. Significantly, the Georgia Supreme Court's denial of Kendrick's emergency petition focused on Chief Judge Glanville's violation of the recusal rules. Yeah, even if Georgia Supreme Court denied this motion, they can still use the information in that denial. And denial was not about you were wrong, it was you filed it to the wrong court. The court emphasized the portion of this rule that reads, if it is found that a motion is timely, the affidavit is sufficient, and that recusal would be authorized if some or all of the facts set forth in the affidavit are true, another judge shall be assigned to hear the motion to recuse. Instead, Glanville properly found that the Weinstein affidavit contains assertion of fact to support the allegation of bias and impartiality, which by law should have ended his inquiry. Chief Judge Glanville must then refer the recusal motion to a neutral judge to decide the merits of the motion pursuant to that rule. Glanville's factual review of the Weinstein affidavit is particularly astounding, given that Chief Judge Glanville has repeatedly refused to give defense counsel access to a full transcript of the secret ex parte proceeding. It is apparent that Glanville has made every effort to keep the proceeding a secret and inaccessible to defense counsel, going so far as to hold Steele in criminal contempt for refusing to provide the name of our source and to issue an order to show cause to Kayla Bumpus in an attempt to silence her. Glanville has recently indicated he may provide a redacted transcript of the proceeding prior to Copeland's cross-examination. Glanville has scheduled an in-camera meeting with prosecutors and defense attorney on July 1st. That's on Monday, to review the transcript of the secret ex parte hearing, but it is unclear today if defense counsel will see the entire transcript and what, if any, portion will be made public. Glanville is still indicated that any transcript provided will be redacted to remove, quote, privileged information. What could be privileged in a proceeding among Chief Judge Glanville, the prosecution, sworn witness Copeland, and Copeland's attorney is a mystery. Glanville failed to follow that rule. Proper procedure requires referring a motion to recuse to an unbiased judge after the 3 prongs of that rule have been met. C. Glanville has violated multiple rules of the Georgia Code of Judicial Conduct. The facts alleged in the Weinstein affidavit must be assumed true when deciding whether recusal would be warranted. The detail learned by Weinstein include the holding of an improper ex parte proceeding conducted with sworn witness Copeland. This violates Kendrick's rights to due process and a fair trial. The secret ex parte proceeding with sworn witness Copeland was also a violation of at least 2.9 of the Georgia Code of Judicial Conduct. Dun, dun, dun. And footnote, and footnote, and footnote, and footnote, which assures every person of a fair hearing. Quote, ex parte communications are presumed to have been in error. Not only did Chief Judge Glanville fail to notify defense counsel about ex parte proceeding as required, but Glanville made every effort to conceal that proceeding. As Attorney Lester Tate states in paragraph 14 in his affidavit in Exhibit C, in reviewing the video of the exchange between Judge Glanville and Attorney Steele, there was no disclosure of the ex parte proceeding, which is now the subject of the show cause order. Indeed, quite the opposite takes place. Judge Glanville not only failed to disclose, he sought to keep others from disclosing and to punish those who might already have disclosed. Georgia Code of Judicial Conduct, this rule, quote, says generally that judges shall disqualify themselves in any proceeding in which their impartiality might reasonably be questioned, followed by a non-exclusive list of specific situations in which recusal is required. The standard is an objective one. Quote, the facts must be considered from the perspective of a reasonable person, rather from the perception of interested parties or their lawyer advocates, or from the subjective perspective of the judge whose continued presence in the case is at issue. Furthermore, Glanville should not have coerced sworn witness Copeland to testify. Quote, a trial judge should not attempt to intimidate a witness to testify in behalf of the state, either in or out of the presence of the jury. A few case law. As the Georgia Supreme Court wrote, quote, we need not decide whether such bias and impartiality actually existed, because judges are ethically bound to disqualify themselves whenever their impartiality might reasonably be questioned, including instances where the judge's behavior could indicate that he or she, quote, has personal bias or prejudice concerning a party or a party's lawyer. Defendants will not provide a notice of the hearing. Defense counsel should have been afforded an opportunity to attend any hearing where a sworn witness is in a critical stage of the trial, is being coerced to testify. The only logical conclusion for the secret nature of the proceeding was to give Judge Glanville, in conjunction with the state, the unfettered ability to harass and intimidate the sworn witness into testifying. As the motion to recuse met all requirements, Glanville must assign the motion to recuse to another judge for consideration of the merits. I'm getting thirsty here. How are you all doing? Good, I hope. Hit the like button. Rule 2.1 of the Georgia Code of Judicial Conduct reads that judges shall respect and comply with the law and shall act at all times in a manner that promotes public confidence in the independence, integrity, and impartiality of the judiciary. Yeah, he haven't done that this entire trial. In the hearing of June 12th, Glanville failed to follow this rule by failing to make the determination required in a timely fashion. Petitioner need not repeat the details of Glanville's actions here. Glanville's failure to follow the requirements of Rule 25, both on June 12 and 14, were a violation of the Georgia Code of Judicial Conduct. Conclusion. Judge Glanville's actions offend public confidence in the independence, integrity, and impartiality of the judiciary. An appearance of impropriety and bias hangs over the present trial due to Glanville's failure to follow the law. As Attorney Tate writes in paragraph 15 of his affidavit, here we have a judge who has failed to abide by a provision of the Code of Judicial Conduct designed to assure a fair hearing, and who also have actively attempted to conceal the proceeding. In my opinion, to a reasonable degree of legal certainty, this conduct legitimately calls into question the judge's impartiality and, assuming it to be true, would require recusal. Again, I reached this conclusion based on Glanville's actions, not any ruling that he has made in the course of this trial. Petitioner requests a writ directing Chief Judge Glanville to follow the law. Based on Glanville's own findings, Glanville should be directed to assign the motion for recusal to an unbiased judge for hearing on the merits. Petitioner is further requesting a writ ordering Chief Judge Glanville to immediately produce an unredacted transcript to defendants of the ex parte proceeding. Petitioner also requests any further writs or orders it deems appropriate given Chief Judge Glanville's action. Respectfully submitted. So these are the first 25 pages. And verification, yeah, this is just Mandamus Nisi. Now I have unless conditional rule of order of the court. The petition of the Monte Kendrick in the above captioned case having been read and considered, the same is hereby sanctioned and ordered filed, and it is further ordered that the respondent's Chief Judge Oral Glanville appear before me. Oh, this is the suggestion to the judge who will probably be, who hopefully will see this. So this is just the suggestion that a copy of said petition and this order be served upon respondent. Exhibit A is this is a motion to recuse. This is the actual motion to recuse. I've read this before on a separate stream and in a video, I believe, so you can just go look for that. Let's see, Exhibit B, if it's anywhere around here. Exhibit B, Rule Nisi. This is the suggestion to the judge who will preside, or hopefully will preside. This is the suggested order to appear. Certification of service. And then it's the Weinstein affidavit. And this we already went through. Let's see here. Exhibit B is another order or motion. And also this is something that we have already went through. Most of what's in here is something we already went through. C is state of, affidavit of Lester Tate. This I haven't read yet. Comes now as Lester Tate III, personally appearing before the undersigned, and who, upon being sworn, states as follows. He's over the age. Yeah, that is he's the owner of the law firm, Lester Tate Law Group. And as to his experience, this is just him showing to the reader, yeah, I have all the credentials needed. He's licensed to practice law. This is his other experience. But now we get to the meat of the one. While I have not attended any of the trial in state of Georgia v. Jeffrey William et al., Fulton County Superior Court case, this court case, I have watched various video recordings of the proceedings, including the exchange between Fulton County Superior Court Chief Judge Glanville and trial attorney Brian Steele, in which Steele raised the issue of an ex parte meeting with the witness lawyer, and prosecutors. This in-court exchange ultimately led to Glanville holding Steele in contempt of court, an order which has now been appealed to the Supreme Court and stayed pending resolution of the appeal. I have specifically reviewed the order holding Steele in contempt of court and the show cause order issued by Judge Glanville, directing parties to the ex parte meeting to show cause why they should not be held in contempt. Sorry. The opinions I express in this affidavit are based on a review of those video clips and a review of the attack exhibit. I express no opinion in this affidavit that is based on any ruling made by Glanville. Instead, my opinions herein are based solely on his conduct failing to comply with the Code of Judicial Conduct. Based on the show cause order, it is now apparent that an ex parte meeting took place in Glanville's chambers on the morning of June 10th. This meeting is specifically referenced in the show cause order, in which Glanville directs all participants in that meeting to appear. Since I do not know for certain what took place in that meeting or why it was necessary, I am assuming, for the purposes of this affidavit only, that there was a legitimate purpose for the meeting that is allowed by the Code of Judicial Conduct. Rule 2.9 of the Code of Judicial Conduct recognizes that from time to time there may be need for an ex parte communication. In pertinent part, Rule 2.9 reads, judges shall accord to every person who has a legal interest in a proceeding or that person's lawyer the right to be heard according to law. Judges shall not initiate, permit, or consider ex parte communications or consider other communications made to them outside of the presence of the parties or the lawyers concerning a pending proceeding or impending matter, subject to the following exceptions. Exception is 1. Where circumstances require, ex parte communications are authorized for scheduling, administrative purposes, or emergencies that do not deal with substantive matters or issues on the merits, provided that the judge reasonably believes that no party will gain a procedural, substantive, or tactical advantage as a result of the ex parte communications, and B, the judge makes provision promptly to notify all other parties of the substance of the ex parte communication and gives the parties an opportunity to respond. This rule, however, also requires in unequivocal terms that any judge who has ex parte contact must promptly notify all other parties of that communication and give them an opportunity to respond. Failure to follow this procedure is a violation of Code of Judicial Conduct, irrespective of the reason for the ex parte communication and regardless of when the contact occurs. In other words, the judge must give prompt notice of communications that happens in trial and in some other context than outside of trial. I would further note that Rule 2.9 has implications beyond judicial discipline. The heading of the rule is, quote, assuring fair hearings and averting ex parte communications, end quote. Therefore, a violation of this rule is not just something a judge could get in trouble for. It is also a rule that assures that the parties to a case get a fair hearing. In reviewing the video of the exchange between Glanville and Steele, there was no disclosure of the ex parte meeting, which is now the subject of the show cause order. Indeed, quite the opposite takes place. Glanville not only failed to disclose, he sought to keep others from disclosing and to punish those who might already have disclosed. Rule 2.11 provides that, quote, judges shall disqualify themselves in any proceeding in which their impartiality might reasonably be questioned. Here we have a judge who has failed to abide by a provision of the Code of Judicial Conduct designed to assure a fair hearing, and who also has actively attempted to conceal the meeting. In my opinion, to a reasonable degree of legal certainty, this conduct legitimately calls into question the judge's impartiality, and assuming it to be true would require recusal. Again, I reached this conclusion based on Glanville's actions, not any ruling that he has made in the course of this trial. From Lester Tate. Exhibit D, let's see. Oh, this is Kayla Bumpers. Motion to quash order to show cause and motion to recuse this court. Comes now. Attorney Kayla Bumpers, through undersigned counsel, and files this motion to quash the court's order to show cause, filed June 11th, 2024, or in the alternative moves this court to transfer this action to another judge or recuse itself as required by law. In support thereof, Attorney Bumpers shows the following. Recitation of the facts. On Friday, June 7, during the trial, the state immunized Kenneth Copeland and called him as a witness. Copeland refused to testify. The court placed Copeland in custody over the weekend for his refusal and adjourned until Monday. At this point, Copeland was still sworn as a witness and had not been dismissed. On Monday, June 10th, Copeland and his lawyer, Kayla Bumpers, were escorted to this court's chambers and conducted an ex parte meeting regarding whether Copeland would testify. Those present for the substantive portion of this ex parte meeting was Glanville, Copeland, Bumpers, Adrian Love, Simone Hilton, members of the court's security staff and deputies, 2 investigators from the district attorney's office, and a court reporter. In chambers, this court asked Copeland whether he was prepared to testify. Copeland announced that he planned to again invoke his Fifth Amendment privilege on the stand. A conversation among the parties ensued regarding Copeland's understanding of the immunity, how Copeland thought he may testify if he did not invoke the Fifth, and certain facts of the case. Once Copeland learned that he could be held indefinitely by the court if he refused to testify, not just 2 years, Copeland decided that he would testify. Copeland added that his testimony would be a lie. The meeting ended and the parties went to the courtroom. Now, Kayla Bumpers here leaves out a lot of information. I don't know why. But yeah, so there is differences in the different affidavits. This ex parte meeting was not placed on the seal. There was no protective order that directed the disclosure of these ex parte communications was prohibited. No attorney-client privilege existed. Clearly, as 2 prosecutors, investigators, a judge, a court reporter, and various court staff were also present. The court never stated, ruled, or inferred that the meeting was meant to be confidential. Further, the content of this meeting was not secret, protected, or in any way privileged information. It is unclear why any person present would have understood that the content of the meeting could not be shared with other attorneys of record in the case, who are also with fellow officers of the court. Later the same day, defense counsel, Attorney Brian Steele, addressed this court to make a record of his due process concern regarding the ex parte meeting. The content of said meeting would not just be non-confidential, but would usually be given to the defense under Giglio and Brady. During Steele's attempt to put his due process concern on the record, this court began to focus on the identity of the source who leaked the meeting to defense counsel. The court ordered Attorney Steele to provide the name of the person who divulged the existence and content of the ex parte meeting. Steele refused. A brief hearing followed, and what initially appeared to be a classic civil contempt action, the attorney could purge himself of contempt if he provided the information to the judge, became a criminal contempt action. The court found Attorney Steele in direct criminal contempt. This court sentenced Attorney Steele to the maximum time allowed, which was 20 days to serve in Fulton County Jail. On June 11th, 2024, this court entered a show cause order directing all individuals that were present for the ex parte conversation that took place in the court's chambers on the morning of June 10th, specifically Copeland and Copeland, his attorney, Bumpus, quote, and all representatives of the state and court security personnel that were in attendance, to show cause, quote, why one or more of them should not be held in contempt for disclosing information from the ex parte conversation to members of the defense counsel. No specific names were included in the order, other than Copeland and Bumpus. Argument. The court seeks to hold in contempt the person that leaked the ex parte meeting to defense counsel. Thus, the contempt hearing will be about who informed defense counsel, whether to find that person guilty of criminal contempt, and if contempt is found, the appropriate punishment. The procedures that a trial court must follow to hold up the acts alleged to constitute the contempt were committed in court or committed out of court. My tongue is getting tired. Think of my SO. In this statute, the quote, disclosing information from the ex parte conversation to members of the defense counsel occurred not in open court or in chambers, but at the time and location that defense counsel were notified of the ex parte meeting. Further, direct contempt involves contemptuous conduct in the presence of the court, which generally results in immediate punishment. Here, the need for punishment is clearly not immediate, as demonstrated by the show cause order being set 2 weeks out from the order. Forms of contempt are further divided into criminal and civil, based on the nature of punishment imposed. Civil contempt is a conditional punishment intended to coerce the contemptor to comply with the court's order. By contrast, criminal contempt imposes unconditional punishment for prior contempt to preserve the court's authority and to punish disobedience of its orders. The contempt alleged by this court of disclosing information from the ex parte conversation to members of the defense counsel could only be criminal contempt. Nothing can be done to purge or undo the alleged contemptuous act, and any punishment would amount to criminal contempt. A. No contemptuous conduct occurred. There neither is nor was anything preventing the disclosure of this ex parte meeting to defense counsel. Disclosure did not violate a court order. There is no standing order in place or trial order that bars or in any way limits defense counsel for witnesses or any other individuals present at the ex parte meeting from communicating with defense counsel for the defendants about the meeting and its contents. To the extent that the show cause order may be subject to a general demur, the order cannot pass this test. Assuming that as true the allegation of disclosing information from the ex parte conversation to members of the defense counsel, contemptuous conduct is not alleged. Furthermore, contempt may be found only where the attorney knows or reasonably should be aware, in view of all the circumstances, especially the heat of controversy, that he is exceeding the outermost limit of his proper role and hindering rather than facilitating the search for truth. In Jefferson, disclosure of the meeting did not exceed the limits of anyone's proper role, and, if anything, the disclosure facilitated the search for truth. A judge may reasonably expect his clerks or other judges to keep what happens in chambers professionally private. However, they are under no legal duty to do so. Such an expectation of privacy do not extend to third parties, not part of the court's staff. Holding an ex parte meeting in chambers did not impose a duty of secrecy. Informing counsel for defense of the existence and content of this chamber meeting did not violate any rule of law, trial order, or standing order, and is not a basis for contempt. The show cause order failing to articulate an act of contempt should be quashed. This court must transfer this contempt matter to another judge under the procedure for indirect contempt, or alternatively recuse itself pursuant to Georgia Code of Judicial Conduct. Yeah, this is, we read this before. It's about, Glanville did bad, he should recuse himself. Let's see if there are any other exhibits. And she has a bunch of attorneys. Certificate of service. This is the order to show cause. The court has been presented with an issue of contempt for determination all individuals that were present for the ex parte conversation that took place in the court chambers on the morning of June 10th, to include the witness, Mr. Kenneth Copeland, his attorney, Ms. Kayla Bumpus, and all representatives of the state and court security personnel that were in attendance, are hereby ordered to show cause before the Honorable Juror Glanville. While one or more of them should not be held in contempt for disclosing information from the ex parte conversation to members of the defense counsel, it is further ordered that the failure of any of the individuals who were present for the June 10th ex parte conversation will cause the court to direct the Fulton County Sheriff's Office to take them into custody and bring them to the bar of this court. Judge Glanville. And affidavit, Caliph Adams. This is just a reiteration of what happened. So it's just another to boost the other affidavits. And this is the Supreme Court order. I did that in a separate video, so you can read that there. Hi, Christine. Yeah, Samantha writes over here, if Glanville doesn't delete the spicy part first, it doesn't really matter anymore. It doesn't really matter anymore. He did a bad thing. He did an extremely, extremely bad thing. And I've said it before, and I will say it again. The only time Judge Glanville should be allowed into a courtroom ever again is if he is the defendant. Okay, now it's after midnight. I've been adding up this for 5 hours. If you want another hour out of me, let's just say we're only $20 to the next spin of the wheel. So if you want me to go on for another hour, 10 of you, $2 each. Or one of you, $20 in Super Chat, gifted memberships, or via PayPal. Oh, I haven't checked PayPal for a bit. Maybe there's something there. Nope. I will give you a few minutes to think about it. It's so bad. It's so bad lighting. Like, I mean, this is my new home office, and it is right by the window. As you can see, it is dark outside. Hey, Christine, you have been a member for 11 months. Thank you so much for your support. Thank you so much for your support. my poor girlfriend, my tongue is worn out. Do I have one more here? Let's see here. Yes, I have a cooler. Oh! Ta-da! So you have to the end of this beer. Cheers. Now let's see. So good daily, do you have any news? Nope. Okay, let's get back to this and start listening again to this argument about if they should or shouldn't play certain parts of the videos.
I'm gonna exclude that from 701-42 to 702-26. The rest of it, can be played. And I believe you all have excluded, actually, you've excluded 702-26 to 703-08 by agreement. Is there anything else in that segment that I need to rule upon?
Can I understand the court's ruling? So
I'm gonna exclude 701-52 to 702-26.
can we understand what the basis is?
It's speculation.
But Your Honor, we literally just let in speculation for the last, everything that the
That's
defense,
impeachment, though. It's not
but it was
impeachment.
impeachment based on speculation.
It's impeachment.
And what part is the court believing is speculation?
Madam, I'm ruling, okay? I've ruled. 701-52 to 702-26 is not gonna be played. Okay? You all have agreed upon 702-26 to 703-08 to be excluded. So is there anything else in that particular segment that I need to resolve? That should take care of it, right?
For that
Yes, ma'am.
area, yes, Your Honor?
Okay, all right. Next portion.
Second time period, I believe that we may be in agreement with the state about this. It's 703-16 to 704-36. It's discussion about Kenneth Copeland's girlfriend named Deshawn at the time, her stepfather. It's discussion about her stepfather. And I don't think it has any relevance in this case. And I think we're in agreement with that. Is that correct, Ms. Hilton?
Yes.
Okay. So that would be 703-16 to 704-36.
Is that gonna be excluded, Ms. Hilton?
Yes.
Okay, all right. Next period.
The next period was 723-49 to 730-23, I believe. We're gonna
730-23,
yes, and we're gonna withdraw a request.
withdrawn.
Your Honor, I think this is covered from what we discussed earlier.
In which section?
It may be.
This is the entire number 4, I believe,
One.
or these portions of number 4.
Yeah, we covered that in number 4, so already. Because number 4 is 722 to 724-54.
Yes, Your Honor. The only difference was there's the certain and earlier you ruled we can play it.
What's
The part where Mr. Copeland does not, basically the state in their suggested redaction was started earlier to take out the part about Kenneth Copeland having the opportunity to say what he supposedly learned on January 10th, but not saying it, and you ruled in our favor on that. And so
you're gonna be able to cross on that.
right.
Yes.
Okay.
And I want to be clear because this entire portion, 723-49 through 730-23, although they're withdrawing it, it covers what was number 4 and number 5 on the state's redaction. So we won't be playing it because our understanding is the defense agrees with 5. There was no dispute as to 5.
Yeah, we didn't, 5, there was no disagreement on 5. 5, the only disagreements I had were 4, 9, 11, 14, and 16.
Correct. So I just want to be clear that although they're withdrawing it, the number 3 is inclusive of what's in 4 and 5 on the state's redaction.
Number 3 in terms of what? What are you talking
Number
about?
3 on the defenses.
Number three is, I'm sorry, I may have misnumbered it, but 1 is the, well, how do you have it?
Did you get the email that I sent to defense with the defendant's proposed redactions?
Yes, ma'am, I have it.
So that may make it easier.
Which one is the defense, though?
So the entire document I just emailed at lunch is all the defenses, their proposed redactions.
And Your Honor, you can, for the purposes of this, it references 2 different times. You can ignore the first column because we're just going off the state's videos times to simplify things.
The timestamp?
Right. So the first column is defense redaction times. You can ignore those times because we're just to be universal.
I don't think I have that one. I think I just have, I don't know if I got that. Let me just see. Ms. Holton, did you send that to me
Yes.
as well?
I believe so.
I have it now. Let's see.
Yeah, it was sent at 2:22.
All right, for purpose of discussion, I'll include this in next court's exhibit in order. And I'll forward to Ms. Weaver. All right, so which one do you want me to disregard, Mr. Sharp? Defense redaction times?
Right, just for the ease of this
And
conversation,
to go
we'll just
with-
focus on the evidence reviewer times.
Okay, all right. So have we covered, which ones have we covered so far? Or are we covering right now?
We're on the defense number 3,
Okay,
which the state is stating that time frame is inclusive of what is on the states 4 and 5.
I get it.
The problem is, and I'm kind of speaking for everyone, Mr. Steele, when we were discussing the state's requests, indicated a desire to get into on cross-examination as impeachment, what's in 4 and 5. So while I'm withdrawing my request on behalf of Mr. Stillwell, and Mr. Steele, I think, wants to get into the topics from 723.49 to 730.23.
So we didn't discuss that because initially we
Right.
said that was going to be agreed, at least for the purposes of this conversation, agreed upon. So we didn't have any discussions of the state's number 5 because we're just learning now that that's going to be objective.
It goes back to what you heard about Rich Homie Kwan putting $25,000 on, according to Kenneth Copeland, Rich Homie Kwan putting $25,000 on someone's head. Those discussions, that's what comes in during this time period. And I believe you said that Mr. Steele could talk about that on cross-examination.
Yes. So do we have any more discussion about it?
No.
Okay, all right. Which one are we dealing with next?
Number 4 is from 742.21 to 747.02. And that, I'm not, there's a gentleman who is on our indictment that's not sitting at trial with us. I don't even want to say the person's name, who was once falsely accused of rape. And the officers make reference to how people that he was charged with did him dirty because they all knew he didn't commit the rape, but they basically let him sit in jail and let him sit there and take the blame for this rape.
Your Honor, that's not a dispute. That's consistent with the state's number 8.
Okay.
I'm sorry, Ms. Hilton, I didn't quite hear the last thing you said. It's not
It's not
disputed
a
what?
dispute. It's consistent with the state's number 8.
Okay, so we're not gonna talk about that.
Okay.
That's excluded. Next.
750.00 to 750.56.
Mhm.
It's the police investigator Dennis and Gaither asked Kenneth Copeland about his knowledge of, essentially there was apparently a shooting outside a hotel where Jeffrey Williams' fiance was throwing some sort of hotel party. And the police asked Kenneth Copeland what he knows about that shooting and how it's related to the Donovan Thomas shooting. Kenneth Copeland, in response, knows nothing about it. He's like, I don't even know about that. And then the police kind of tell him about it and put that in the atmosphere, where Kenneth Copeland is completely lacking any knowledge of it, is my recollection. So essentially, it's not even what Kenneth Copeland says. It's the police start talking about this shooting. And that's not proper and should be redacted.
So they're talking, so from 750 to 756, they're talking about some unrelated shooting?
Unrelated shooting at a hotel party that was thrown by Jeffrey Williams' girlfriend at the time, I believe, or the mother of his child. And right, it's unrelated. It's never been linked to this case. And Kenneth Copeland knows nothing about it.
All right, let me find out the state's gonna talk about it.
Yes, Your Honor. This particular shooting was discussed while Detective Dennis was on the stand. He discussed a series of events that occurred in the days leading up to the Donovan Thomas murder. And this is one of the shootings that he discussed on the stand. The reason why the state wants to send is because the defendant's theory, even in the midst of this motions argument, is that Mr. Copeland was just lying throughout every part of these interviews. And what this portion shows is when he was unaware of something, he told the detectives, I don't know about that. I have no idea. So it shows that he was trying to be truthful with the things that he knew and the things that he didn't know. And if the defense is going to cross-examine Mr. Copeland as to whether or not he's being truthful in this interview, this here shows that the officers are talking to him about a shooting that they believe is relevant to what happened in the days leading up to the murder of Donovan Thomas. I believe this shooting happened on maybe the Thursday or the Friday before Mr. Thomas was murdered. And they're talking to him about this event. This was a shooting that happened outside of the W Hotel. And they're asking him about if he has any information about it, if he was aware of it. And Mr. Copeland says, no, I didn't even hear about that. Matter of fact, I met Mr. Williams at the studio that night. And so again.
So he had no knowledge about it. He just heard about it. This is stupid.
This rebuts this notion that Mr. Copeland was just trying to lie and make up stories the entire interview. And that's in a direct contradiction to what they're going to try to say about Mr. Copeland. So we believe it's relevant. The information about the shooting has already come out in testimony from Detective Dennis when he testified a few weeks ago. And so it is relevant to show that Mr. Copeland was not just trying to make stuff up in the course of this interview.
Well, the problem is that these statements, the alleged purpose is to show Mr. Copeland's inconsistencies, and he offers no statement about
You
this.
can cross him on. I mean, that's the whole point. I mean, is that he may end up at some of the things that he said may be truthful and some may not be.
Right. I guess my point is with this particular excerpt, it's not even what Mr. Copeland says. It's what Investigator Dennis and Gaither said that comes out. And it's not even a Kenneth Copeland issue. And these statements are allegedly being played for the purpose, like the origin of why we're playing these is to show Mr. Copeland's inconsistencies. And in this excerpt, Mr. Copeland doesn't really say anything. So.
Do you need a page number, Your Honor?
Is it 138, line 11 to page 140, line 22?
Yes.
All right, let me read it.
All right, I finished the beer. We didn't reach the spin of the wheel. And it's almost 5.5 hours in on a Friday. So somehow I will get back to covering the things I missed in this hearing. But that won't be today. I'm a bit tired and I had a few beers. I'm going to send you over to somebody I've never watched, but the subject is really interesting. Yay! You've been following me for almost a year. Now, the subject I'm going to send you over to is Logan Paul has sued Coffeezilla for revealing that Logan Paul may or may not be a scam. So I will be sending you all over to that. And it's a small channel. It currently only, it's only 36 people watching. So go over there. If you like it, you like it. If you don't, you don't. I don't know. Yeah, I know. I need paintings or something. I need to bling this up. But again, thank you all so much for showing up. Thank you for allowing me to do this. Thank you for the gifted memberships. Thank you. Hug your family. Unless your family is crap, then screw them and give your love to the people who deserve it. I will see you all back here tomorrow on the Jodi Arias trial coverage. All right. See you tomorrow. Bye-bye.